Mr. Edmonds, can you hear us? Makai Edmonds, can you hear us?
Yeah.
How are we proceeding?
Your people have a witness present and have extended what this court usually described as not an offer of HIDA. And I will defer to the defense on how we will proceed.
At this time, with the offer being made, my understanding based on the last time we were here that he was to be released. After we made contact with him, the offer for HIDA was extended this morning. I've not been able to speak with him on that offer yet. Just to confirm, last I spoke with him, he was interested in HIDA, but at this point, I would like to continue the trial, but with a deadline of a week to allow him to go over that offer that was not an offer.
He did not post his bond. Why is he in custody?
That's my confusion as well, but because at least based on what happened last time, I thought that he was going to be released in order to provide payment payroll information at the last bond hearing, just to prove that he was in fact it shows here that he is still here on this chart, which speak to because it was my understanding that he was going to be bonded, that he had received a bond on that.
What's going on with this felony matter?
The only thing is,
Mr. Edmonds, why are you in custody?
When I came to court for you last time, I had waited 7 days to get the PR, but my court date had got switched from my other case, and she had sentenced me to a couple weeks in here, so I ain't never get off.
So you're in jail because of your matter before Judge Stokes. Is that what you're saying?
Yes, ma'am.
The matter scheduled for trial, that is September 8th at 8 o'clock in the morning, in person at the court. Any additional matters for the record?
Nothing from the people.
no, you're right.
You're all set, Mr. Edmonds.
Thank you.
You're welcome.
Just a question, Mr. Glenn, now you got a GPS telephone.
Sorry?
You got a GPS telephone, want me to send it to GSC?
No, we don't have authority to keep phone on. This is the State of Michigan versus Markia Jones, 26-01414.
Ross Marshmead for the people.
Assistant Public Defender Justice Strong on behalf of Ms. Markia Jones, who is standing to my right.
Okay, Ms. Jones was scheduled today for final pre-trial. This is for a domestic violence. Is there a witness here?
No, Your Honor, my approach people have prepared a motion for nolle pros.
So we're moving to dismiss without prejudice. The motion is granted, but the people do have the right to reissue this charge against you. You understand that, ma'am? Do you have any questions at this time? Any additional matters for the record?
Nothing on behalf of the people.
Nothing from defendant. Thank you.
You're all set. We'll get your copy in a minute. State of Michigan versus Stephanie Lyra, 25-01694. Appearance, please.
Ross Marshmead for the people.
Assistant Public Defender Joseph Hardy on behalf of Ms. Lyra. Right now, we're just finishing up a plea sheet. Ms. Lyra will be pleading for the agreement guilty to count 1, with count 2 to be dismissed.
That is correct, Your Honor. Finishing the plea sheet.
Ms. Lyra, you want to plead guilty to one count of assault and battery?
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Can you hear me?
Yeah, yes,
Solemnly swear or affirm to tell the truth and the whole truth under the penalty of perjury.
yes,
Put your hand down. Yeah, in this matter to proceed to a jury trial and to maintain your innocence. You're innocent until proven guilty, and you can require the prosecution prove each element of the charges of assault and battery at the time of a jury trial. Do you understand that?
yes,
The right to hear or question any witness called to testify against you, the right to subpoena witnesses that will testify on your behalf, the right to remain silent and not have silence be used against you, and you could waive your silence and give testimony at your trial or present defenses that you believe you have to this charge. You understand that?
Yes, ma'am.
To unconditionally waive these rights so that you can plead guilty, correct?
Correct.
Is anyone threatening you to get you to enter a guilty plea? Is there anyone threatening you to get you to plead guilty?
No, ma'am.
Has there been any promises stated or offered to you in exchange for a guilty plea today? If you're responding, we're not receiving the response.
Ma'am.
Okay. Are you currently on probation or on parole?
No.
Okay, you understand that by pleading guilty, it can result in the conviction that you may need to report to your employer.
Yes.
It also could have impact on where you can travel or get immigration status. So you may want to travel out the country and they could deny you entry into their country because you have a criminal conviction. Do you understand that?
Yes.
As to one count of assault and battery and count one, how do you plead?
Guilty.
Is that because you believe you are guilty?
I'm sorry, what?
Is that because you believe you are guilty?
Yeah.
On a factual basis.
Thank you, Your Honor. Ms. Lyra, is it true that on March 28th, 2025, you were at 2514 West Jolly Road?
Yes.
And that's in the city of Lansing? And that's in the city of Lansing,
Correct. Yes.
within the county of Ingham, state of Michigan?
Yes.
Is it true that at this location on this date that you got into an altercation with a Gianni Rosario? Stick up. Okay. And on this date, what did you do that makes you guilty?
I shoved her.
And is it true that this was not self-defense?
Correct.
People are satisfied with the factual basis, Your Honor.
The court is also satisfied with the factual basis. I'll accept your plea. Finding your plea to be freely, voluntarily, and intelligently made. What are we doing with the bond violation? Were you aware she had a bond violation? It does not appear she was arraigned, to be honest with you.
I do not believe I was made aware of that.
Okay, I do have a bond violation here. It's unclear that you were arraigned. It said the bond violation was received from 56th District Court. I do believe, though, at the time you were in warrant status here. Let's see. I don't know why they would not have arraigned you because you saw the judge or the magistrate on the 29th. But they said that they received the bond violation on the 1st, so maybe they hadn't sent it over. I have a police report, case incident number here. This is from Meridian Township Police, case number 262602361. The allegations are that on or about June 29th, 2026, that you had contact with the police, and at the time you were under the influence of alcohol in violation of your bond conditions, that you had a PBT of 0.22 on PBT number 4. And so that's a violation of your bond condition, that you were not to have any drugs or alcohol while out on bond. You have the right to have a contested hearing. You have the right to be represented by your attorney at that hearing. If you're found to be in violation of your bond, you could be facing 93 days in jail for the bond violation. Do you understand that?
Yes.
Okay. And did you want to have your attorney represent you on a bond violation? I didn't hear a response, but I assume so.
Yeah.
This matter, okay, very good. So we'll set it for a hearing will enter a not guilty plea at this time because your attorney was not advised of a bond violation, nor does he have any discovery relative to it. It'll be set for hearing the same date as your sentencing, which is going to be September 15th at 9 o'clock in the morning, in person at the court. You do need to meet with our probation department. They're going to prepare a pre-sentence report and interview you to get some data for the court to consider as part of your sentencing. Let's see. Is she being held on anything else other than this?
Not to my knowledge, Your Honor, she's not popping up in the online jail roster. Not aware of any other cases that could be pending. All I know is that she currently has a cash surety bond in this case.
Any additional matters for the record?
Nothing from people.
No, Your Honor.
You're all set, ma'am. You're all set, Ms. Lyra.
Thank you. Oh, I had a question.
Yes, ma'am.
Bond,
Your sound is going in and out, so can you repeat it again?
do I have a bond?
Yes, you've had a bond. It's $300 cash surety. So you can either pay $300 or you can get a bondsman. Pay $30.
Okay.
Pay $30.
You,
Okay, you're all set. State of Michigan versus Jason Walker, 26-00866. Appearance, please.
Ross Martinez for the people.
Blackman on behalf of Mr. Walker.
Mr. Blackman is substituted. Okay, today was the date scheduled for a bond violation and a final pretrial. How are we proceeding?
I represent him also in the court for the felony charges. I'm just getting on it, so I'm going to be asking the court if the court consider setting another final pretrial date. I just talked to the assistant prosecutor. I need to talk to the potential resolution of this matter. In addition to that, I would like to address his bond.
You want another final pretrial? Do we have a witness here?
We do not have a witness around the underlying case. I was planning on making a forfeiture motion, which you did not hear in my jail.
Oh,
But it sounds like we might be able to make a resolution.
it's not. He was arraigned on the 30th on allegations of jail costs. I have 2 more bond violations since then.
You admit to those.
July 1st, July 16th. Let's see what they are. For more phone calls.
My understanding is he used a different inmate's account after his criminal was restricted.
You want to make a what after this, you said? I don't know if I understood.
Judge, I didn't know about the new calls. And so what I was also, I was going to be asking the court, he's been in jail now 21 days.
Yeah.
And I was asking, and if I can lay it out a little bit, Judge, Judge Aquilina was aware of all this also. I've got a document that she would not proceed or violate his bond up in circuit on the case I have. We have a pretrial September 9th at 9 o'clock with her on the felony. His mother, his stepmother's in the courtroom, and I would not want to cross her. He's going to be living with her, and she is going to give him, because his father, somebody else in the family have not helped him in this contact. She's really upset with that. And she would address the court and tell this court how she feels about all that and what would happen. Thirdly, he's on tether in circuit court. That has not been revoked. You know, if the court would allow him to be released, I would facilitate the victim being added to his circuit court tether and zones of exclusion on that at this point. So I'm leaving it up to the discretion of the court. If the court wants to speak with Miss White, who is sitting in the courtroom, I think she'd be impressed with her also too.
I might be impressed by her.
But
It's
you're
Mr.
not
Walker,
impressed with my
I'm not
client.
impressed
Yeah,
with.
I know. But she is, and she said me either, and she's real upset with what's going on.
Mr. Marchino.
I share in the concerns that I believe the court has about his bond, given that he was here in court, made a record of the fact that there were bond violations coming his way, and he made it very clear you are not supposed to be using the phone to contact her, and privileges were restricted. His response to that was to let a buddy get someone else's phone so he can continue violating the court order. So, you know, if he's not complying with court orders while in jail, knowing that we are monitoring what he's doing, I don't see how you would comply with court orders if he's released.
I'll listen to his stepmother and see what she has to say. I don't know that it's going to change my position. State your name for the record, ma'am.
Hi, my name is Natasha White,
Can you spell it, please?
Napaushia.
And you are his stepmother?
Yes, ma'am.
Okay. Who's his father?
His father is out of state working right now. He's got a job working in Georgia, so that's where he's at right now. And his mother lives in Arizona. So I wasn't aware either of the recent stuff, of course, because I didn't have anything to do with that, but I am aware of previous, and I do know that his father and them, they don't really facilitate any consequences with him. And so hence why we are where we're at with a 19-year-old right now. When I came in his life, I was getting him ready to finish school and do all kinds of things. His parents asked me to kind of step back because like I have 4 children. I have one getting ready to be a lawyer. She'll be done in another year or so. And I'm kind of stern, you know what I mean? His dad's gonna be gone for a couple months. I would definitely take over ownership or whatever, because I'm not gonna play with him. I'm not his immediate parent. So, you know, my feelings are more so just trying to keep him out of jail and keep him on the right path. I do believe once he gets out of here, I don't think me and him will have a problem with getting him back in school. I work at Capital Area Michigan Works through the state, which gives education and things like that and pays for the education. And I am already in the process of trying to get him set up for school for that when he gets released. So I do have a few things that I'm trying to get in order for him to try to keep him on the right way. I did not know about the new stuff. I can't understand your concern about that because I'm also concerned about it because I mean, he just came to court, you know what I mean? And literally said, okay, I'm not gonna do it. And he literally did it again and tried to go behind your back to undermine you. And I totally get that. And whatever you would say or do, I can totally understand, but just know that I'm not his parents and I'm not gonna play around with him. So just know that, and he knows me, so he knows that he'll have consequences to deal with me for what he is doing. So I do ask that you let him go with me. I do promise to make sure he comes back. I'll make sure that he's in school and doing some other things so that he is a productive person in society instead of going down the road that he's going right now.
Mr. Walker has demonstrated a reckless disregard for a court order. If you're in jail and the judge tells you you're not to do anything and tells you you're gonna be actually charged with witness tampering, then you leave the court and immediately proceed to make calls with another inmate's number to further tamper with the witness. And some of these communications as alleged, because I have some transcripts here or some verbiage, he's being hostile and threatening to her in the messages, in the phone calls. I'm not releasing him. Absolutely not. He has no control. I don't believe you can control him either. You can be as stern as you want. He's a 19-year-old man now. And if his parents, that's why I asked where his father is. It's all, you shouldn't have to be in here advocating for him. His daddy should have been in here advocating. But you're not going to be charged. I don't care what's going on in the circuit court. That has nothing to do with me. How long has the circuit court case been pending?
No, it's a 26 case, Judge. I would say probably about 8-9 months.
Which would mean that he had that case first.
Yes, yes.
Reckless disregard for court order. You're not supposed to commit any assaultive actions or pick up any new cases when you are out on bond. And because he was on bond then, the presumption here was he wasn't even eligible for a PR bond. So he didn't get a PR bond. He got 1,010%. Then he posts the bond only to continue to allegedly violate the bond. And now there's a concern about the witness. Witness is not here. It's witness tampering is the allegation. So more charges. If I release him, you can't control who he's talking to. I can find out who he's talking to now. And he did this to himself. So he's facing up to 93 days in jail per violation. The bond motion is denied.
Thank you, Judge. Good judge. Would the court give us another date for?
Yes.
August 11th at 8.
August 11th at 8 a.m. That will be for final pretrial and PA 53 hearings on these violations. They can have violations here from June 30th through June 3rd of contact and violation of his bond conditions.
At June 30th through July 30th?
Correct. And then there's another violation alleged, but this is from. Oh, it must also be contact, okay. But I believe I actually already arranged it. So there's 3 violations, separate violations for me. Do we need to set up for a jury trial at this time? That was jury trial date. I know, that's why I'm asking, I'm asking them, do they want them to disrupt trial date? Do you want me to set it for another jury trial date? Because I just converted the jury trial to another final pretrial. Do you want a new jury trial?
Oh, yeah, let's have another jury trial date after that.
Just to make sure.
Thank you.
September 29th at 8 a.m. That works for you, Mr. Blackman.
It does, Judge.
Any additional matters for the record?
I think on behalf of people.
On behalf of the judge, thank you.
I don't think I need to tell you what your bond conditions are because you reiterate them in your jail calls. You're all set. This is State of Michigan versus Ivan Pruden, 26-01058. Appearance, please.
Cross March, you know, for the people.
Assistant Public Defender of Justice Party. Mr. Pruden is making his way to the podium. And Commissioner Courtroom. Here.
Where they do the panels? The building's still broken?
Yes, your field property.
No, it's
At least on our.
the water main broke.
Yeah,
They're unable to use chilling on only this side of the building. Meaning, and specifically named my courtroom and Judge Flores,
That's my
which we
friend.
were already getting limited chilling anyways.
Wait,
So-
there was chilling in here?
That's what they
Yeah.
claim.
I
That's what they claim in the
need a
email.
citation on that.
But now there's a water main break. But we got lights today and that's what counts.
It's fair.
No blackout today, just yesterday. This is Lampier. Okay, let's see. Mr. Pruden is going to plead guilty to domestic violence with no objection to sentencing under 769.4A. Is that correct?
That is correct, Your Honor.
Correct, Your Honor.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can put your hand down. This is an advice of rights and plea information sheet. This is your signature. Okay. And you understand the rights listed here? You have any questions about those rights? You understand that in order to plead guilty, you would need to waive all of those rights, which include your right to be presumed innocent until they can prove you guilty. You understand that? You have the right to require the prosecution prove each element of the charge of domestic violence beyond a reasonable doubt. You have the right to require that the prosecution prove each element of domestic violence, and they have to prove each element beyond a reasonable doubt. You understand that? You have the right at any trial to see, hear, or question any witness called to testify against you. You can subpoena witnesses by right to testify on your behalf, the right to present testimony and evidence that you think show a defense of domestic violence. And you can remain silent at trial. They cannot use it against you, but you can waive your silence and take the stand and give your own testimony. You understand that? Is anyone threatening you to get you to give these rights up? Has there been any promises extended to get you to waive these rights? Are you on probation or on parole? Okay. You have any other criminal matters pending? Okay, you understand that by pleading guilty, it could result in a conviction that you may need to either report to your current employer, or you may need to put this on a future job application. It also can have impact in where you can travel or get immigration. So you might want to go out the country for the weekend and they could say, no, you can't enter our country because you have a criminal conviction. You understand that? As to domestic violence, how do you plead? How the charge is domestic violence. You understand that? Is that because you believe you are guilty? Nope. I asked him a question that does not need you to help him. Do you believe you are guilty of domestic violence? You don't know if you're guilty of domestic violence? It's either yes, no, or you may not know because maybe you don't recall the incident. Do you recall the incident that's alleged? Is there a competency concern?
To this point, I believe that on our conversations that he had understood the charges against him. So
So you're not, is there a competency concern, yes or no?
based upon the past 5 minutes, yes.
Okay, but you didn't have one prior?
No.
Okay, and so, Mr. Pruden, you understand the charge of domestic violence? Do you understand you're being charged with domestic violence? But domestic violence is a misdemeanor. You understand that?
I don't know everything about court stuff.
No, that's why I'm here to make sure you understand. Because you can't plead if you don't even understand. Do you understand that?
Yes.
Okay, so do you understand that you're being charged with domestic violence, which is the allegation that you assaulted and battered a person by the name of Caitlin Wallace? You understand that? and that at the time you all were either living in the same house or in a dating relationship. You understand that? And that at the time of the alleged assault, you either had been in a dating relationship or you were living in the same house. You understand that? Okay. And you understand that it has a maximum penalty of up to 93 days in jail or a fine of $500. You understand that that's the maximum sentence? And then that the way it's being offered to you is that if you plead guilty, there will be no objection to you doing a term of probation under a statute that if you're successful will make this non-public. Do you understand that? Okay. And do you also understand that you cannot plead guilty unless you are guilty? Do you understand that? Do you believe you are guilty of what I just said you were guilty of? Okay, tell me what you did to make you guilty of domestic violence. You pushed who? What's her name?
Wallace.
Her name is Wallace. Is that her last name? What's her first name? You know her? Caitlin? Okay, okay. And who was Caitlin Wallace, or who was she to you?
My fiance.
She was your fiance. And what date do you recall this happening?
Don't remember.
Okay, does April 21st, 2026 sound familiar? Or would you object to that date? You don't dispute that it's that date though, do you?
I don't remember that day.
Okay, so on or about that date, you said you pushed Caitlin. Why did you push her?
He ran my vehicle and injured a minor.
She rammed your vehicle
Yes, ma'am.
and injured her. You were driving
Or
or you were inside the
I
vehicle?
was in the vehicle.
Okay,
I was next to it.
you were next to her and she rammed the vehicle
Yes, ma'am.
and injured a minor? Okay, okay, and so you didn't do this in self-defense? Did she get out of the vehicle after she did this?
She was not out of the vehicle yet.
Okay, so she rammed your vehicle with your vehicle parked? Okay, and then you approached her vehicle after this? And then tell me what happened.
Got in, but lightly pushed her. I don't believe in like fully violent. I pushed her.
You pushed her for what purpose?
That she injured and damaged my property. Well, it damaged my property and injured the minor.
So you pushed her lightly.
Yes, ma'am.
Any other question? Where did this happen? Can you tell me the address?
It's near, it was near the mega Bev. I don't know if the address is.
Okay, it was near the Mega Bev. So this was it at Cedar and Holmes? Okay, is it in Lansing?
I think it's near Reeltown.
Near
I
real
don't know if
time?
it's in
So
that-
is that Lansing?
I don't know Lansing. I'm not from Lansing, so I don't know.
Oh,
if
where are you
that
from?
is, Mulligan.
Okay, how long have you been in this area? How did you know it was Rio Town?
I've been in Lansing. I just don't live in Lansing, so I don't know everything.
Okay, so then you know Rio Town is in Lansing. Okay, so was this location in Lansing?
I didn't know if they had different postal codes. That's all.
Well, I'm not asking about the postal code. I'm just asking if it's in the city of Lansing. Is that in Ingham County?
So I don't know the lines of the counties.
You don't dispute that it's in Ingham County, though? Any further factual basis?
I think we got her, Your Honor.
Yeah, no quick questions.
Okay, the court is satisfied with the factual basis. I'll accept your plea and find your plea to be freely, voluntarily, and intelligently made. Is the witness here?
She is, Your Honor, yes.
Any objection to immediate sentencing?
May I consult with her first?
Yes.
Your Honor, the people have no objection to immediate sentencing. The victim is present but does not wish to address this witness.
And the defense has no objection as well.
That's a victim.
Yes, sir.
Oh, you can have a seat at the door. Thank you. You can make allocation.
Thank you, Your Honor. So, Mr. Pruden, he's someone who, is fully remorseful for what he's done. He's currently, he's currently holding down a job and is just trying to make amends. At this point, we would just ask that the court just follow the plea agreement and sentence him to sentences 9.48 probation, so he can successfully complete this and move out to 5.
Did your client want to make a statement on his behalf? Where are we going? What's happening? Where are we on the tour? No, ma'am. Let me see something. Okay. I don't see any prior criminal history, so I believe he's eligible for 769.4A. The concern I have is one of two things is going on, I believe, Mr. Pruden, is that you are they not being we're not being forthcoming on the factual basis or there may be some kind of cognitive delay. That's the only thing I can extract from the exchange. I asked you, you believe you were guilty. We can be really strong in our beliefs. Yes, I was guilty. I wasn't, or you can say, I don't believe I was because of her actions. But that, I didn't get either. The other concern is the statement that you made in reference to what you did to make you guilty, and is that you pushed her lightly because of the incident. And I'm not saying that if true, the incident's not concerning, but the downplay of I pushed her lightly is what the concern is in this moment. And then the follow-up statement that I don't fully believe in violence. Well, did you push her or did you not? Did you push her or no? Okay, and she had just allegedly damaged your property, correct? And she had allegedly put someone else's child at risk of harm, correct? And so you were annoyed, weren't you? So you pushed her. You reacted. Is that correct? That's what I want to hear you say. Not to say that you should be proud of it. I can assess that you're not proud of your actions. But you've got to be able to explain to me what you did and acknowledge that it's wrong before I can believe that you can understand why you're being placed on probation. You understand that? Oh. So a term of probation is appropriate in this matter. You are employed, is my understanding. Is that full-time?
Yes.
Okay, so you're going to be required to maintain employment and provide evidence of that to probation. I'm also going to order that you do participate in the domestic violence programming, just so you can understand better the impact of domestic violence. I don't believe that this is an issue or will be an issue for you. I think the circumstances were concerning for you. You probably didn't know how to handle it in that moment. And maybe this course will give you some better tools about how to handle situations like this in the future, if you were to find yourself in that particular situation, okay? Okay. Just based off what I see here, I don't believe I have an issue that warrants anger management, so I will not order that at this time. But you are not to possess a firearm or ammunition or any other weapon while you're on probation. You understand that? You are not to engage in any assaultive or threatening behavior. You understand that? What is your address? The Boyer Road? Okay. And that's not the address of the alleged victim, correct? I'll continue the no contact order at this time with the victim. So you're still not to have contact directly or indirectly with her, okay? You're not to use or possess alcohol, marijuana, or controlled substance without a valid prescription. You're not to use kratom. I am not going to order testing at this time because I don't believe this had anything to do with his drinking any substance. There is a $30 per month. I don't know if I said it, I'm putting you on 6 months probation. There's a $30 per month oversight fee for each month of probation that you'll be responsible for, okay? So it's about $180 for the $75 crime victim rights fee, plus a $50 state minimum cost that you also are responsible for. I'll waive discretionary fines and costs. So your total fines and costs are going to be $305, and you'll make monthly payments on that, okay? And I will grant 769.48. When you leave here, you'll go down one floor, check in with probation. And you'll be later receiving information or communication from them about my order for your sentence. And then you'll report monthly to probation via Zoom, okay? You have any questions at this time? Any additional matters for the record?
Nothing from the people.
No, you're
You're all set, sir. Thank you. Best wishes. State of Michigan versus Tracy Young, 26-01123.
Ross March, meet on behalf of the people.
Michael Pluckett was a public defender on behalf of Mr. Young, who was not to approach.
Matter is scheduled for final pretrial today for aggravated assault. Mr. Young?
Yes.
You're in a pretty deep sleep over there.
Yeah.
What's going on?
Things,
Excuse me?
a lot of things.
Right, stand up, please. Why are you sleeping that deeply? We called your name. Your attorney had to shake you twice.
Things going on in where I live.
Excuse me?
Things is going on where I live.
That kept you up from sleeping? Is that what you're saying?
You know, it kept me up from not sleeping.
Well, that's what I said, kept you up from sleeping.
Right.
Okay, so you aren't sleeping at home?
Things, you know,
Do we have a witness here?
No, Your Honor, people have a knowledge here, if I may approach.
Yes. The people are moving to dismiss this case without prejudice, okay, sir? That means the case, they can reissue it within the statutory time frame. Do you have any questions about that?
No.
We'll get you a copy when the court officer returns, and hopefully you can get better rest outside the court, okay? You're all set. Oh, you have to have a tether removed, correct?
Yeah.
You need to go back down to either Ingham County or to JSG to have it removed, okay?
okay,
Thank you.
Somebody else, in the jail coming in. State of Michigan versus Jordan Herendeen, 26-01793. Appearance, please.
Ross March, meet on behalf of the people.
Assistant Public Defender Justice Strauss on behalf of Ms. Gordon Herring, who is seated to my right.
This is retail fraud third, pre-trial. How are we proceeding?
Your Honor, the people have made a plea offer in this case in which the defendant would plead guilty as charged in the sentencing agreement to no front jail. I will defer to the defense as far as how we proceed today.
Thought I have Jordan Herendeen on probation. You do. When did I put Jordan on probation?
For April 21st.
Oh, so there's a probation violation.
That's what I just was looking for. I don't see that they entered anything
Who's your probation officer?
in a job.
You don't, not sure? Why not? I can't hear you. Why not? You don't have a reason? Have you been reporting to probation? Okay, but you don't think it's important to know who your probation officer is? Oh, you didn't find it important to know who your probation officer is? You have the probation officer come up, please. Yeah. You have a seat. Oh, and they can bring the file. In the courtroom, a seat in the courtroom. No, I'm not gonna be looking for Jordan later. Jordan likes to run off. State of Michigan. Versus Michael Pratt, 264706231. Appearance, please.
Ross March, meet on behalf of the people.
Good morning, Your Honor. Attorney Jeffrey Maynard, P55243 for Mr. Pratt. This is a civil infraction. I waive his appearance.
the violation of seatbelt. How is he proceeding?
Your Honor, we've reached an agreement to amend this to impeding.
That is correct, Your Honor.
His fine is $135. When is he paying?
Your Honor, I apologize. I'm having trouble with my video getting it to face me for some reason.
I know, you stopped your video because you were walking around
Oh,
your
there it
office. We didn't want to show all your business.
No problem. Sorry
Okay.
about that.
You're fine. Okay, so the fine is $135. Is he paying today?
I can make sure he does, Your Honor.
Okay, well, no, he'll make payment today, and then that will resolve that matter. Any additional matters for the record?
No, Your Honor. Thank
Nothing
you.
else,
Thank you.
not for people.
Thank you. Okay, State of Michigan versus Lamar Wilson, 23-00904.
Ross March, me on behalf of the people.
Michael Plucker, the public defender, on behalf of Mr. Wilson, who is standing to my
Wilson has a retail fraud third degree pretrial. How are we proceeding?
Your Honor, I believe at this time, the defense will be requesting an additional pretrial to see if this matter is solved.
Your voice went really low after the additional pretrial, so I don't know, you said. after
Oh,
that.
sorry, to request an additional pretrial to see if we can get this matter resolved.
Okay. Mr. Wilson, are you okay?
I'm fine.
Okay.
August 18th at 10.
August 18th at 10, okay? You have any questions?
No,
Okay, any additional matters for the record?
Nothing for people.
nothing from the defense, Your Honor. Thank you.
We'll get you a notice, sir. State of Michigan versus Maurice Gary, 26-00002. Appearance, please.
Ross March, me on for people.
Assistant Public Defender Joseph Carney and Mr. Gary.
Okay, this was a sentencing after jury trial. If it's not referring to probation, you can make allocation.
First, before making the allocution, since it is 21 days since the, it's within the 21 days since the jury verdict, I'd like to make a motion for judgment notwithstanding the verdict under MCR 2.610, with the reason being, we believe that the jury came to a conclusion that was not supported by law or fact. We believe that reasonable doubt was supplied as to this matter. So we would ask for the judgment to be overturned or for a motion for a new trial, Your Honor.
Telling me what your beliefs are. You have to also tell me facts to support your beliefs.
Yes, so we believe that there was very much doubt supplied through the testimony of the witnesses as to the authority that they possessed to initiate contact in this matter. We believe that reasonable doubt was supplied as to whether there was any type of physical contact initiated by Mr. Gary, and we believe that there was reasonable doubt also as to whether any of Mr. Gary's actions caused the injury to first security guard. We understand that injury is not required as it was not aggravated. However, I think that this is relevant to the restitution request that was made, alleging that he had missed his work because of his injury. So I want to get out of that.
Well, Mr. Hardy hasn't presented the court with any sort of case law that arguing that it's not clear if they were given authority by the employer to prevent him from entering the premises is a legal defense. At the end of the day, I think that if the defendant doesn't like the verdict and is asking the court to overrule the jury and 6 people who are in this gun with not guilt, I would request a motion for that.
You said he didn't provide any legal authority to say what?
To say, I believe part of his argument was that, well, we don't know that the victims in this matter had the authority to intercede when the defendant tried to enter the building. And Mr. Hardy did not present any legal authority suggesting that that would be a defense to assault and battery.
A defense to assault, but it would have been your burden to prove that they had the authority to.
Our burden was to prove a harmful or offensive contact, and the jury believed that we met that.
I think it was a question of the jury as to whether or not the officers had the authority to either go hands-on or block his entry, to which we told them they had to rely on the proofs that was submitted. You're now positioning yourself to say that because they failed to establish the authority, and that was a question I think you asked the witness at the time of the trial as to whether and what their policy was, which they were unclear about whether or not they have the authority to go hands-on. And so what if they did have the authority?
If they did have the authority,
And we don't know because it's hypothetical. They've not provided evidence as to one way or the other.
they did have the authority, I do believe that they would be within their legal rights to initiate contact with him. Let's feel like this into what was previously a verbal confrontation, turning into a physical confrontation. Beginning with the arm. Some would call it a grab. Some would call it was just impeding his progress. Either way, physical contact was initiated. I believe that if the alternative, if there was proven that there was no authority, then I do believe that very scary would be within his right to claim that this was self-defense, to claim that he himself was assaulted, to claim that his personal rights were violated in this manner.
But that was something he could have always claimed. He could have claimed that at the time of the trial. Never asserted a claim of self-defense.
Yes, and if they did, once again, if they had the authority, I believe that they would have had the right to initiate physical contact, but without that authority, I don't believe that they were in the right to
apply force.
To apply force in this manner.
I think the problem is that you want me to dismiss the case based off something that's not an element of the charge. It's something that really goes to a defense, which you have to assert. You have to assert the defense, it was self-defense, and then he now has to prove it was not self-defense. He would then be required to prove, well, the reason why it's not self-defense is because they did have the lawful authority to make physical contact with him. The prosecution was never put on to require to put that on as to prove that beyond a reasonable doubt, because you never placed a defense on the record as it relates to self-defense. So now they're not required to prove that it wasn't self-defense. So it was vague whether or not they had the authority. The officer himself didn't know what their policy was. That was completely vague. The jury could have easily said it was too vague. And so because of that, we don't know. I think that requires argument during your closing to explain that to a jury before they go there. If you get back there and you still have questions and they're still vague, you cannot find him guilty beyond a reasonable doubt. These are not arguments that were made to this jury. And so you leave it to the jury to now try to fill in blanks and figure out gut feelings or whatever's going on. You left the security officer on the jury who had a policy in her work that she can go hands-on Just because that's the policy where she works doesn't mean that's the policy at Crystal Ray, which is where they're, and I don't know what the policy is for security purposes. Crystal Ray provides a community service, and typically they're dealing with people who have some pre-exposure to mental health concerns. Overall, I think the case was not a good case because of those elements. It's a situation where we already have people coming here to get resource, and more likely to not have some mental health concern. But the case went through the jury. I'm not going to now overturn the jury's verdict because of that. If there had been a assertion of a defense that this was self-defense, then I would have no choice but to overturn it, because he's failed at this point to prove that it wasn't self-defense, because he never established whether or not they had authority. But that was not, self-defense was not ever implicated in this case. So we can't now assert it at the time of sentence. It has to be asserted before or during the trial, which then places the burden on the prosecution to prove that it's not self-defense. So self-defense is not a matter of this. I didn't refer him to probation because of the circumstances. Again, poor judgment on, I think, all parties, but I think poor judgment on you. Because if they tell you you can't enter, you can't barge your way in. If there's a policy about you getting searched again, you leave outside for a smoke break, you gotta get searched again. I mean, that's the same as if you come in this building. I think Mr. Marchmita might have used that as his example. If you're in this building, if any one of these people sitting back there in this building and they need to go pay their meter, they have to go through security again. You can't just say, well, I left my bag upstairs. Okay, well, you gotta go through security and get searched again, and then you can go get your bag. And you can't, I don't know what was said. We couldn't hear any audio. I saw the exchange. It looks like there was some level of search, maybe not pat down for him, but there was some search that happened. But based on the understanding that they believed that there was a threat, they were restricting his access. I thought that there was a better way to maybe assure him he would get his things, because it sounds like that's what the concern was. I want my stuff. And so, but that didn't happen. And even if they don't assure that they're going to get your things, you still don't get or have the right to use force to force your way into the building. I also don't believe that he is the cause for any knee injury. I think that witness lacks some credibility then in how he phrased his knee going out. Then it changed a little bit. And I think that he probably had a bad knee. So as it relates to any restitution, I don't think that they were seeking restitution.
I forwarded restitution information along to Mr. Hardy. It sounds like that the court's not inclined to grant restitution, but just to make a record of it, I was forwarded pay stubs from the victim in this matter, indicated he has not been able to work since this incident. After tax pay was $403.73 a week. And he indicated he's missed 30 weeks, which totaled to $12,111.90. Then he also has received, I think it's some sort of disability payment in the amount of $8,816.15. So the people were going to request $3,295.75. I do believe that the evidence was clear that regardless of the background on this, obviously the court disagrees.
There was no evidence as to an injury that was caused by his actions that caused this man to miss 30 weeks of work. There was absolutely no evidence put on the record for that. There was a statement about his knee went out. And when questioned about his knee situation, he became vague and tried to scale back the statement. But no, there was no, he never even unequivocally testified, no, he kicked me in my knee or he did anything. The other thing that is primary is that in the state of Michigan, you're a security officer and you get injured in the duty, your exclusive remedy is workers' comp. So why is he not at work? I don't know. If he wants to pursue him civilly, he can do that, but he's not getting any restitution from what I've heard in court for 30 weeks of missing work for that incident that I saw. I think he had a bad knee. And I think he stated that.
Would the court entertain the possibility of a restitution hearing?
I will entertain the possibility of him proceeding in civil court if he wants to get that kind of money out of this person for that incident. He's gonna have to prove the injuries and prove the injuries directly relate to this action. Absolutely not. Not gonna use this situation to linchpin and now get 30 weeks of unpaid work. I don't think so. I don't even believe that the video was demonstrative of that level of interaction that warranted 30 work weeks missed because of an alleged knee injury. He didn't, there was nothing he could even answer on direct or cross that said that this person caused the injury. He said his knee went out.
Well, I think the last thing I would say is that, injury was not an element that of this charge.
Agreed.
So I think that if there were a restitution hearing, you have the opportunity to really flesh out the detail causing this injury and background on his knee, why he hasn't been to work, what other sorts of issues he might have. It sounds as though the court has made its decision. So.
It's not meaningful. It's not meaningful. Do you work? I don't think so. This is a person that's going to Crystal Ray to get some resources.
Well, a victim has a right to restitution regardless of the ability to defend.
He does have a right to restitution. Where's the medical bills? Was any medical bills put on the record? If it was so bad that he needed to miss 30 weeks of work, this should have been an aggravated assault.
Understood.
That was not how this was charged. It was charged as an assault. So no, if he wants to seek that kind of recovery, he's got to do that under a civil court.
Understood.
Thank you. Any other allocution?
Yes, so right now, Mr. Gary is currently under probation, Judge Cole, for a CCW offense. So if the court is inclined, first we would ask that he be given time served. He has to approve for 1 day. And
You said what?
we'd ask that he be given time served for the day that he spent, just because I think that the nature of the assault was not one where there were any punches or kicks thrown. I don't believe that this was any type of vicious assault. I think this was a physical confrontation that got out of hand, and the jury found that his actions amounted to an assault. But I don't believe that his actions were enough to warrant any longer time in jail than what he's already spent. In the alternative, with him currently being under probation for which he is been compliant with, we would ask that if the court is inclined to order probation, that just the terms of the probation be that he has to follow the terms of his current probation.
And how long is he on probation for?
So it's IDA, so it's hard to get public facing information, and he said that he was on probation for a year, and it looks like the deposition of that case was so just based on internal files, looks like he was sentenced on that case. January 5th of this year. So just by my math, looks like he would be on probation with Judge Cole until at least January 5th, 2027. And that's high.
Okay, given 4 months of non-reporting probations to be compliant with all of his circuit court probation requirements. Complete anger management. Not engaging in the assaultive or threatening behavior. Do you have any questions, sir? Any additional matters for the record?
I think I already have to do that.
No, you're
You're all set. He'll go downstairs and check in with probation, sir. Back on the record in the matter of the state of Michigan versus Jordan Herondine, I think I have information here. Let's see. Is that your probation officer? What's your name?
Joseph something.
What's his name? Okay. I'm saying you need to remember his last name, but you should know your probation officer's name. His name is Joseph. Okay? Am I talking to myself? I said, okay, you didn't respond. Okay. So the reason why I called you up, Mr. Sumter, is because I have a case here of a retail fraud, third degree from my 7th, and I didn't see a probation violation.
I did not know about this.
So I need to make sure that while I have Jordan here, I can address both if possible, a probation violation. Because obviously the alleged incident here having occurred on July 6th would have triggered a violation there. So would you need a copy of something out of this file?
I do not.
Okay. How are we addressing this retail fraud third?
So as noted, we extended an offer in which the individual is charged with guilty of jail. I don't know if the court would feel inclined to honor such an agreement in light of the defense probation status, but that is our status as of now.
Thank you. Is your client been participating in mental health counseling? No? Wasn't that my order? Why are you not participating in mental health counseling? Excuse me? Have you gone to community mental health? So what do you mean you can't afford it? Community mental health gives free counseling and resource. You haven't gone and I ordered it as part of your probation. That's literally the main thing I ordered as your probation, to participate in mental health counseling. And not only have you not done it, you picked up a new case. I'm sorry?
I was stealing milk at 3:30 in the morning.
Is that a guilty plea? You might need to counsel your client. If your client's not going to participate in probation, I have to put him in jail.
I think she might actually be amenable to that, Your Honor.
Going to jail?
She would like to schedule going to jail, yes.
The schedule?
Yes.
It won't be a schedule. This is not the doctor's appointment. I told Jordan to go get mental health counseling in April. It's July. No mental health counseling, new case.
I can say, Your Honor, that some social workers from our office, we recently had a transition in social workers. So the person who had previously been assigned to this case just handed that case off to another social worker in our office. She has been attempting to make contact with Ms. Herondine. I think they've been missing each other. But I do think the plan is to get her connected to community mental health.
It doesn't take a lot of planning. This is the kind of the issue I had even in the first case. It's just this energy of I don't need to do what I'm supposed to do. Even when I'm talking to Jordan, they ask you what's your probation officer. I don't know. Doesn't care. I say you don't think it's important. Explain after Mr. Sumter comes up that it's important for you to know at minimum your probation officer's name. And Jordan's response is nothing. I said, okay, nothing. Because Jordan doesn't want to do probation. So I'm gonna go ahead and remand Jordan revoke probation pending a hearing on the violation. And then if Jordan wants to enter a formal plea, although haven't already admitted to stealing milk in the middle of the night from Quality Dairy, I'm assuming. If there wants to be a formal plea, that can happen. And then we can do one group sentencing on the violation and the new case. And then I can make sure mental health counseling happens because I can order it from the jail. Sounds like a plan.
Really would not like to miss my birthday on the 28th. I can just report here after my birthday. I can very good. And I'm open to whatever you have to.
Oh, you think this is an open negotiation? I gave you probation. I gave you leniency after you had that other case.
I just
Can you give me that case?
I don't have the funds. I can't.
No, you could have went to community mental health. You could have gone and got help. I have it here, you're on probation when you were originally charged with an aggravated assault on mental health worker or medical worker. And because of your circumstances, I said, hey, just do probation and get engaged in your counseling. And you didn't do that. It doesn't cost you anything to go down to community mental health. The only thing you do that, you don't think it's important for you to do probation. You don't even think you need to know your probation officer's name. That's because you don't think it's important. What you think is important is celebrating your birthday. What I think is important is making sure you get the help that you need so that we don't have other acts or spiraling acts.
Like we have a party on my birthday. I don't party. I just wanna be out on my birthday.
You have to have your priorities. And your birthday, I'm not scheduling you to come in for another court date. That's not gonna happen.
Just report to me for not a certain.
No, you're going to be remanded today. I'm gonna set this for a hearing. You wanna set it for a plea? And I'm set it for a bond violation hearing. You have the right to have a hearing on the bond violation that you violated the conditions of your bond by picking up a new charge. If you're found to be in violation of your not bond, probation, your probation can be revoked. You can be sentenced to the original term of jail time. Do you understand that?
August 4th at 10:30.
August 4th at 10:30 for both a plea and a probation violation hearing. I'm ordering a screening and treatment while you're in the custody of the jail for mental health.
I'll give you your medications. I was just saying, yeah.
I'm sorry, I can't hear you. You said they did what with your medication?
They didn't give her medication.
And I just, if I can have another chance of probation.
Well, we can talk about that on August 4th.
I just got out of jail committee to say that that was the violation.
I'm sorry?
I just
She's
got out of.
asking for time served
I just.
Time served for what?
for the probation violation.
Absolutely not. She didn't serve time on the probation violation. She has no time served on the probation violation. So where are we getting the time? What are you talking about?
Recently incarcerated.
That has nothing to do with the probation violation. I don't know what you were incarcerated for.
For the retail fund. Your Honor.
Oh, that has nothing to do with the probation violation. If you do not receive your medication, you need to submit a kite immediately, but I have put an order in the probation file. I'm gonna also put in the retail file to ensure that you're getting your medication and your mental health treatment. If you get a problem with TikTok Tays, you let me know.
I sure will.
Any additional matters for the record?
Nothing on behalf of the people.
I think we did that, thank you.
You're all set. State of Michigan versus Christopher Lewandowski, 26-00305.
Ready, Your Honor.
Your Honor, may I briefly go? We have a crime victim present. Have it go grab it.
Yes.
Thank you.
Your appearance, please.
Yes, good morning, Your Honor. Joshua Nushin, I'm here on behalf of Christopher Lewandowski, who stands to my right.
Okay, he's going to go and get the crime victim, but we do have a pre-sentence report. It was prepared on the 16th. You got a copy?
I do have a copy of it, Your Honor. It appears factually accurate. There's no deletions or additions. However, there was a correction I noticed on page 3.
Okay.
I can wait for Ross to come back in. It was to the term of probation.
It says on page 3.
This page, Your Honor.
8-month term.
You have an 8-month term? Says it only gives 14 months of my.
It says 8.
I'll go with you.
Let me see what you're looking at.
All right, so sure.
No, which one? Let's see here. Okay. Let's see that too. Somebody has been emailing us. Possibly.
Nope. That's the woman across the street.
Yeah, I haven't read it. So you get your copy. Let's see. Let's say 14 months here is recommended. 14. So that's not really a change. You just want to argue against it. It's a recommendation.
Yeah.
So
Okay, so we're gonna wait. But yeah, I didn't.
now let's see what this is all about.
Neighbor across the street.
Shannon.
Oh, we had 2 crime victims.
Oh, okay. Who is Shannon? That's Shannon.
Shannon was- Yeah.
Yeah, because she's got some emails to the court. Okay, did you get a copy?
Yes.
You just did.
I did not.
This last one. I highlighted this section. Okay, this is from Melissa's. Are you took it?
Yes, Mrs. Green, and she also has a statement she would like from the attorney.
Is that just right here?
Looks like it. This looks like it's a statement.
Okay,
I think
that's
she
okay.
made some tweets to it.
Sounds good.
Um,
And then there's some pictures.
something sent to you, so-
Well, they went to, I don't know where we turned that down to. Probation. I don't know if Brendan Hammond put this in the file, I think. So. Let us make copies. Don't have any others. And then you can feel free to have the pictures. You can take those pictures though. If you want to see them, I don't think them.
I know. Oh, gosh. I don't think I have a choice, right? I think that might as well get started. That'd be great. Ooh, that's really small. Oh.
He's under 11 pounds.
He's grown quickly.
He's just under 12 weeks and 24.5. Doubled his size in 2 years.
He's getting big.
Little. I'll be kidding. Sure.
I don't know they do that fast.
I have. She's tall. She, that girl. It's gonna be like the dog from Sam.
Both need copies? I think that,
I just need a copy.
yeah, I think that Ross had a copy. He just didn't have the pictures and I'm just giving him our pictures. Ross, okay, Mr. Marchina, you get a copy of the pre-sentence report?
Yes, Your Honor. No deletions, additions, or corrections.
Okay, and you did have a witness that wanted, or a victim that wanted to address report?
She's requested that I address the report on her behalf.
Okay, you can do so.
Well, I understand the court, there have been some revisions since the statement that you received. So just go ahead and read it. It's on behalf of Melissa. Your Honor, I am submitting this statement to explain how the defendant's conduct has affected my life and my family. Although there have been prior issues with the defendant regarding frivolous complaints about our dog, the harassment escalated significantly in June 2024 when the defendant had his teenage son place a threatening note on our door at midnight while wearing a ski mask. The note stated, "It's on, bitch." This incident marked the beginning of a pattern of intimidation that caused my family and me to fear for our safety. Since that time, the defendant has engaged in repeated stalking and harassing behavior. He has followed me to another residence at night, photographed both of my homes, approached my security cameras, demonstrated knowledge of personal information about myself and my family that he should not reasonably know, and repeatedly looked into our backyard to observe our private property and activities. These actions have made us feel watched, unsafe, and unable to enjoy privacy and peace in our home. The defendant has repeatedly yelled profanities and sexual insults in front of our children and guests. He has engaged in ongoing property-related disputes, including attempts to move the property line, flooding our yard with pool water, damaging our grass, breaking our fence, and making statements that he would take our home and assets. He has also repeatedly involved law enforcement and other agencies in matters that did not warrant intervention. He called the police regarding normal activities, including mowing our lawn, falsely accused me of theft, and repeatedly contacted Miss Dig to claiming to be the homeowner of our property. This resulted in our yard being unnecessarily marked multiple times and caused significant disruption, stress, and wasted resources. When I removed the flags from our property as instructed by Miss Dig, he called the police on me again. Most concerning is that the defendant on November 29, 2025, specifically told Officer Burkett that he would not stop because she was not going to do anything about it. Unfortunately, his actions since entering his plea agreement have proven that statement to be true. In my view, this demonstrates not only an awareness of the impact of his actions, but an intent to continue them. As a direct result of the defendant's conduct, including following me to another residence, leaving threats on our door, photographing our property, and engaging in ongoing harassment, we were forced to purchase additional security equipment to protect our family and document incidents. We incurred $203 in expenses for 3 additional cameras, and the necessary accessories that we purchased solely because of the defendant's conduct. These purchases would not have been necessary otherwise. The impact on our family has been substantial. I frequently worry about what may be happening outside my home, particularly when I'm alone with our children. I no longer feel comfortable allowing our children to play outside when the defendant is home, and my partner has largely stopped working in the yard because of concerns that the defendant will create conflict. What should be a place of comfort and security has instead become a source of anxiety and stress. Your Honor, when Mr. Lewandowski accepted the plea agreement, I truly hoped this harassment would finally end. Instead, it has only continued. Since he stood before you last to accept his plea agreement and you warned him to be neighborly, he has been peeping into our private backyard, continued making frivolous police complaints about normal daily activities, which the police determined to be unfounded, maintained cameras pointed directly at our home, including our bedroom and bathroom windows and our yard, repeatedly monitored our property, regularly activated a spotlight that illuminates our children's bedroom, waited in his car for our guests to leave before flicking her off, then following her for several blocks, and worst of all, trapped my cat, Callie, who has been missing ever since, and he is now actively trying to trap my other cats. His actions since accepting responsibility have left me feeling hopeless that this will never end. Rather than showing any remorse or changing his behavior, he has continued to try to find ways to harass my family and try to disturb our quality of life. I respectfully ask the court to give us relief and consider that his conduct after entering his plea demonstrates that without meaningful consequences and strict conditions, this pattern of harassment is going to continue and potentially escalate further. I respectfully request restitution for the $203 spent on the 3 additional security cameras and necessary accessories that were purchased as a direct result of the defendant's conduct. Due to the history with the defendant's stalking behavior, I also ask the court to prohibit the defendant from intentionally monitoring, photographing, recording, or otherwise surveilling me, my family, our guests, or our property. While I understand that neighbors may legitimately use security cameras to monitor their own property, I ask that the court prohibit the defendant from directing cameras, recording devices, lights, or other equipment directly toward our residents in a manner intended to monitor our activities or interfere with the reasonable privacy and enjoyment of our home. I also respectfully ask that as a condition of Mr. Lewandowski's sentence, he be prohibited from having any direct or indirect contact or communication with me, my children, our family members, or our friends. This should include in-person contact, phone calls, text messages, emails, social media, communication through third parties, and nonverbal gestures or any other actions intended to intimidate, harass, or provoke us. Given his ongoing pattern of behavior, I believe these restrictions are necessary to protect my family and friends, prevent further harassment, and allow us to feel safe in our home. I further request that the court prohibit the defendant or a third party on his behalf from using law enforcement, emergency services, utility services, or other government agencies as a means of harassment. I'm not asking that legitimate complaints be prohibited, but that knowingly frivolous, retaliatory, or harassing complaints intended to intimidate or disrupt our family be treated as a violation of probation. I also respectfully request the longest probationary term permitted by law. My concern is based on the defendant's history and my family's experience with it. The defendant was previously on probation and his conduct increased after that probation ended. Given his stated intention not to stop his continued behavior after entering into the agreement and his history of escalating conduct, I believe ongoing supervision is necessary to protect my family and discourage future misconduct. Finally, I strongly urge the court to require a comprehensive mental health evaluation and compliance with any recommended counseling, treatment, or supportive services as a condition of probation. My request is not based on punishment, but on prevention. The defendant's repeated conflicts with neighbors, inability to respect boundaries, continued behavior despite police involvement in criminal charges, and apparent failure to recognize appropriate conduct suggests that intervention is necessary. Addressing the underlying causes of this behavior through treatment, education, and supervision may reduce the likelihood of future harassment, improve community safety, and help prevent similar harm to others. Thank you for your time and consideration. Respectfully submitted, Melissa. And I would also note that you obviously have a written impact statement from Shannon. She also wanted me to just clearly convey that any the other crime victim, Shannon, she requested I clearly convey, knowing that an element of stalking is unconsented conduct, that it's her position that any additional contact from Mr. Lewandowski is unconsented, and that includes ongoing issues from headlights being flashed for extended periods at night into her windows. So that is all that she wanted me to have on her behalf. And as far as the people's position, I would respectfully request that the agreement in this case was to cap probation at 12 months. I would request that the court do impose the full 12-month term of probation, I think that moral recognition therapy would be an appropriate condition of probation in this case to help the defendant understand his own actions and his own role rather than trying to, I guess, blame others. And just in general, I think everyone in this room wants just, it'd be best that everyone just leave each other alone, just try to peacefully coexist. I think that's what everybody wants. And at that point, I will defer to the defense and to the court. Thank you.
We did receive an email or communication, I should say, from Shannon Avalora, which the court has provided to both parties. This is in her impact statement. She said, I am not good at writing those. This is all new to me. I've never had to deal with this before. I did try to write it in a way that the judge could understand some of what we have been through. It's so much hard to put it all down. If you have any questions or need to understand anything further, please don't hesitate to call or email me anytime. I just hope you can help me get him stopped and he and his family just leave us alone. He seems to be trying to see what all he can do to continue to get away with. For example, last week I was outside doing trash and my husband was talking to the mailman who is his work friend. Chris Lewandowski comes outside to get his mail, and he looks at me, then yells something to my husband. It seems like his game is to continue to try to harass and communicate would be against a bond and no contact order he is on. Then 2 days ago, he came outside when I went outside in the evening to water before 100-degree day hit, and he went over to the live traps he had put up and put a camera on it pointing at our home. This was just a stalking and harassment move because he has at least 6 cameras up already pointing towards us in his yard. So the camera is not needed. His other cameras work and can see that the cage clearly from where he had it sitting. Then after he got his camera situated and pointed at me, he sat on the front step and watched me through his cameras from his phone. As some of the cameras light up when they are live viewing. So he sat there almost 30 minutes while I was watering. He likes to continue to stalk and keep me in fear and see what he can get away with. Since this is all new and I never been stalked before, I am not sure if his behavior is loud while he is on bond. It seems like it, to me, it's not. He just seems to not take any of this seriously and wants to continue to campaign to make us fearful. I have lived in this neighborhood almost my entire life. I have many friends and family who live here. We have never had any issues with any neighbors. I take care of my mom, who also lives in this neighborhood in her own home and needs me close. Chris has seen or has been seen sitting in front of her house after he stalked me and followed me to her home. This is unsettling and very concerning. I just hope you can help us with faith to get him stopped. We should not have to deal with this stalking behavior and harassment. This is the second time he's targeted me and had a probation officer. As soon as probation and no contact order ended, he was worse than he was before. It is like he lives to keep this going and escalates instead of learning to leave us alone. He had to take anger management class last time and did nothing. He seems to be very revengeful and wants to make our lives as miserable as possible and fear him. Thank you for listening. Thank you for your help. If you think you need to make sure you have my last impact statement, please contact Marissa Berry at the prosecutor office. I only had hard copies because I don't have a computer, so I ran them up to the officer after I typed them off the library. I went to see the picture of him when he got home one day and saw me sitting on the porch. As soon as he got out of his van, he went to the edge of his property to videotape me. This was included in the report, I think, but it will give you an idea of the bizarre, crazy behavior. I had put my chair sideways and a plant up to block him so that I could maybe sit on my porch and not be stopped. And he found a way around it by going to this. I will send the picture separately. Thank you for all you do. I appreciate your time. Have a nice day. I think I provided you the pictures. Do you have a copy of the pictures? Can I just use those pictures, please? Thank you. This appears to be a picture of a cat. And a cat. Is this you? Who is this? Okay. This is a picture of, I suppose, the defendant with a cat. And it appears as a cat. Is that supposed to be their cat? I don't know what's happening.
We've had them. Melissa has alleged that there is a neighborhood cat that she had been feeding, that she had viewed as her cat, and that Mr. Lewandowski.
This cat?
Yes, and then Mr. Lewandowski trapped it, and she has not seen it since then.
But it's not her cat.
It legally was not her cat.
Oh.
Legally it was a stray. And
This
she
seems
believed
to
it
be
was
cut off.
targeted at her because he knew that it was a cat that she had, some sort of attachment to.
Okay, but the trap was on his property, correct?
I believe that's correct.
Oh. Something about, something's cut off our front yard and one facing our bedroom. I'm assuming, I don't know, this might be, I guess, to show, because the person who wrote this is not here. So I'm not sure what this is supposed to show me. Unless this is their property and it's supposed to show me his camera facing their property.
I think that is what.
Okay, and where do we know where they got these photos from? Was this in the police report or something? How do they get a picture from his camera?
No, I believe that they took a picture of his camera, maybe.
It's probably.
No, this is the vantage point.
It's from their camera.
So
I
then
think
what?
that's a picture of
Oh,
his
okay, so what, is it supposed to be showing me whatever's in this circle? Well, I don't know what that is. I don't know what it is. It's.
Your Honor, the picture I took from my phone of the camera.
And what's your name?
Melissa.
I'm sorry? Melissa?
Yeah. and
Okay, you're
they
the
cut
other
picture
victim?
off. Yeah.
Okay, you know what this is?
Yeah, I took that with my phone. It's showing their one of, well, it's cut off because it shows the cameras that they have pointed directly at our house and our property.
Okay, what is the circle? What
That's
is?
the camera that they have setting on their garbage.
Oh, I thought this was a cup.
No.
Okay, that's a camera on the garbage.
Yeah, and they have 3 other ones facing directly at our bedroom windows, our front yard, and our bathroom.
Okay, but is this is your house on the other side of the gate? Okay. And then,
I think that she was standing on her property taking a picture.
got it, okay. And then these are cameras, you say facing our bedroom and bathroom?
Yeah. That picture was taken from our bedroom window. We can see that the cameras would be facing directly at her.
How can you tell what the vantage point of these cameras are?
The only thing you can look at is like that's directly at our, we have 2 bedroom windows and a bathroom window right there. And
Well,
there's
this
one-
camera looks like it's pointing that way. I got 9 cameras. You can't tell what you can see out that
The only
vantage
thing
point.
in that area is the side of our house.
And you believe that he's got security cameras to watch
The one he
your
set up,
bathroom
he
and your bedroom?
specifically Said when he set it up, now I can see the whole thing.
He can see the whole thing?
Yeah, that's what he said when he set it up.
The whole thing
To
of
our-
what?
To our other camera.
He told it to you?
He told our camera.
He told your camera? So he went and spoke to your camera?
So some of the initial allegations was him repeatedly walking up to their security camera and making threatening and harassing, often sometimes sexual messages to them.
Some sexual comments?
Yes.
Okay, this is another picture of the camera, correct, ma'am?
Yeah, he turned one directly towards our front yard. It used to be facing towards his front.
What is this?
That's the spotlight he has shining into our backyard.
This is your backyard?
That's our backyard, and that's how much.
No, I mean where the light is. It's his backyard?
It's got a pool back there.
What time of day is this, though?
Says on the bottom, I think it's like 11 or 12.
It just says it just says the date.
Oh, it's about 11 or 12 at night.
Okay, and then this is to show us the light through your home?
That's through the kitchen window,
Okay, and what time of day was this? I'm sorry?
around midnight.
Okay. Okay, you're saying he's at the pool at midnight?
Not saying that, I'd like to allocate first.
No, absolutely, you're gonna have, you've gotta allocate because this is a lot.
This is a lot. It's been a lot from day one, and I think the prosecutor will agree with me on that. We have 260 plus videos of neighbors corresponding or lack thereof. But I believe this all started when the Lewandowskis moved into the neighborhood.
Okay, so the others were living there first, the Lewandowskis moved in.
Correct.
Okay.
They have found out Mr. Lewandowski is a registered sex offender.
I saw that and I, not gonna lie, I immediately suspected, I wonder if this is an underlying concern.
So obviously, words were exchanged, which the prosecutor, I mean, we've seen it on videos between the complainant, her partner, to the Lewandowskis about his registration.
Okay.
The complainant's partner had used the weed whacker one day and described pedo into the Lewandowski's front yard. A lot of things have gone haywire.
And I don't wanna break your rhythm, but the only reason why I'm stopping you is because as I was reading one of the impact statements, the first, I wrote notes. Because the statement of leaving something that's a note that says it's on, immediately to me, implies that there was a previous interaction. That's what it implied to me. That's why I wrote it there. Like, why would someone just came and said it's on? That means something was done to them first.
So, and I'm not saying talking in the camera, certain things that were said were acceptable. But this has been going on for quite some time. Police have been out. I think they know everybody within these three houses on a first, middle, and last name basis at this point. Okay. I actually met the Lewandowskis at the house one afternoon, and I let the prosecutor know I was headed there in case we had more police contact. It is very heated. Somebody steps on the other property, 911 is called. Okay. There are more cameras between two houses than you would see in downtown Lansing. Okay. The Lewandowskis have cameras placed around their home to, at this point, protect themselves to a certain extent. They're not doing anything to harass, intimidate people since the plea has been entered. There's been no bond violations. He has been trying to use and enjoy his property the best of his ability. I've sent Ross some pictures in the past about camera placements, even watching some of the Axon camera videos that I've received has a camera angle from the complainant's back garage into my client's sunroom in their backyard. You can see right in waist up. And
you can see
the camera, the video, you could see right into my client's sunroom.
So you had
anybody
video
from the waist
from
up.
inside of the complainant's house looking into his house?
Outside of the complainant's garage.
Okay.
Where they have the
so
camera
you can
mounted.
See, how did you get the video?
It was tendered to me by the prosecutor's office.
Oh, okay. So that you can see that it's directed into his home.
Yes. So, and at this point, my clients can't even speak inside their house without being listened to on, I'm going to say, a low end estimate is 13 cameras that I can see. Even to the tree in the front yard on the adjacent property.
13 cameras on the other property?
Correct. It's like Fort Knox. So, you know, when there's an issue or when Mr. Lewandowski is outside looking at this privacy fence, for example, he's got a pool and the fence has been leaning and it's starting to lean more and more on the property and it's going to become a safety hazard. And he's been instructed by this Lansing Police Department not to touch the fence as it will be a violation of this case. The problem is when that fence falls, his pool then becomes exposed and he's got a bigger liability of somebody falling in it or keeping people out. So he can't even touch his property to fix certain things without a bond violation being alleged or any contact. Like he's at the fence line, which he is allowed to be, looking at the property line and seeing how he can try to jury rig this thing before it collapses. I know that the complainants have put up more cameras since the plea. One is a motion activated light that turns on when the cameras run. And it is literally on the fence post pointing right down the fence line to the street, across the street into Shannon's windows. I mean, it is this setup. When I got there, you can tell exactly which three houses have been feuding for years. And it's unfortunate. Nobody's going to move. Everybody needs to be neighborly. It's affected the Lewandowskis where they can't go outside without running the risk of a bond violation. And for a certain amount of time, he wasn't allowed back in. Then we had him in for work hours. And now he's been there since the time of the plea. And the police haven't made any new arrests. They've come out, I think, once or twice because there was alleged trespassing that somebody might have mowed a portion of somebody else's yard by the fence line. You know, I know that the Lansing police resources have got to just be up to here with this. And, you know, I've advised, you know, my clients were willing to sit down and hash it out with everybody and just kind of put it down. And I think a lot has to do with the SOAR registration status. He's been compliant. He's always been compliant.
This is a conviction from 22
Correct.
years ago.
Correct. It
Yeah,
has.
we don't know any circumstances about anyway. So that, not saying that there's not a concern when you're in a community and you see certain types of neighbors always look up that kind of stuff. And so if you know you have children or whatever, there's not a concern. There's a reason why the sex offender registry is in place. But everyone on the sex offender registry is not a person that is here to cause harm in your community. I remember when I was at the Department of Correction, well, actually at the AG's office, and I was defending a case against the state of Michigan, and one of the defendants was really nervous. He was retired from the Department of Corrections. He pulled me aside. He wanted to let me know I'm nervous because I don't want it to come out that I'm on the sex offender registry. This is a retired officer from the Department of Corrections. The reason why he was on the sex offender registry is because his current wife of 40 years was underage when they started dating. Romeo and Juliet case is what they call it. I say that only to say unless you know the facts of the underlying case, just seeing someone on the sex offender registry should be an alert to you, but does not give you license to decide that they're here to cause harm. I don't know if that's what's going on here. I don't know if there's children in this area or if they're just concerned about their safety. But what is very clear is that no one is being neighborly.
Your Honor, if I may, Melissa has indicated to me that she would like another opportunity to address the court.
She can. You can come up, please. You can come right up to the stand here. So you're raising your hand. What's your name?
My name is Connor Lewandowski.
Oh, this is your dad? Okay.
I don't feel safe going outside.
How old are you?
I'm 16.
You don't feel safe going outside because of what's going on in the neighborhood?
I've been threatened by.
Your Honor, I would object to taking a statement from him before ruling brought for the defendant to speak, for the crime victim to speak, and the prosecutor to speak. I don't believe it's.
Your objection is overruled. You said you feel what?
I feel like unsafe to go outside because I've been threatened by both the neighbors. Been threatened to get my ass beat. My mom has been threatened to get her teeth knocked in by the neighbor, been spit at. And it's really sad that I'm scared to go outside. And like I have friends over and this whole spotlight thing. We have been outside at 11, 12 at night in the pool, just having fun.
And for the record, the reason why I'm overruling your objection is I can receive a statement from any of his character references that want to submit a statement. Has nothing to do with the Crime Victim Right Act.
Thank you, Your Honor. Thank you for explaining.
Connor is the one who put the threat on our door at midnight.
Can you speak up?
Connor is the one who put the threat on our door at midnight. So 2 years ago, he was 14, being sent over by his parents at midnight to put a threat on our door. And he also is on video threatening us after he was arrested as well. So
After Connor was arrested or the dad?
Dad was
Okay.
arrested.
Just for the record, can you state your name?
Melissa Andrus.
Please spell it, please.
MELISSAANDRUS.
Okay.
I just heard a lot of like victim blaming because we did not know he was on the sex offender list for 2 years after they moved in. We didn't even know his name. We were continuously, no problems before they were here. They moved in and it was constant calls about our dogs, nonstop. So we do have a camera on the garage because it's a part of this vantage point to see what the dogs are doing, so we can prove that the dogs are
You
not.
don't have to
barking.
explain to me under any circumstances why you have a camera.
Right.
Nobody
So
has
it
to
is not-
explain. Everyone has the right to put cameras up in their home.
But it is not to be there, it's to watch the dogs, to make sure that the dogs are.
I
doing.
don't believe no one, I would hope no one's
But
paying for
it
camera
has
footage
nothing
to view
to
someone
do-
else.
We did not know that they were on the sex offender list until after we got a ticket for the dogs, in which we won because we have camera footage to show that the dogs were inside the house, they weren't even outside the house. But that's when we found out what his name was. And after that, at some point, we found out that he was on the thing, but it had nothing to do with that. We've never had anything, we've never indicated anything about it. Well, my partner did eventually because he kept scalping our lawn and mowing it down. But this all
You're
started.
saying, well, you're saying I don't know who you're talking about. You're saying Ms.
Mr.
Lewandowski was scalping your lawn?
As soon as they moved in, it started we constantly had animal control and the cops at our house.
Because of your
all the time,
dog?
Because of the dog.
Okay.
And then we were not like tolerating that behavior. We were telling them like, the dogs are not barking. We were showing them video footage of it. And then it escalated because probably because my partner had gotten tired of, they came over into our yard, they mowed it down and it was exposing dirt.
He came into your yard?
Yeah, he was mowing 2 feet
Okay.
into our yard.
There was no fence at the time, is what you're saying?
No, we ended up putting one out, but his wife pulled it out and threw it all over our yard. And that's why we installed more cameras because she started pulling our fence down and our other cameras that were old and we missed it. So we replaced the other ones with new ones so that we could see, because she was tearing our fence down. She was having her son help. So they were out there throwing it all over our yard. And so, yeah, at that point, after 2 years of this constant whatever, he did carve a thing in their yard or whatever, because
He
was
carved the
sick and tired
pedo in
of it.
there?
Yeah, and I was
Because you
mad at him.
already had an
I
ongoing
hollered at him
dispute.
because I told him, I'm like, we have tried very hard not to respond to anything they do. We put up the cameras so that we could see what they were destroying because they were started pulling our fence down. And then he started coming over and talking to the cameras. He started saying stuff about the kids, the younger kid's mom, and telling me that I
Your
need to learn-
children's mom, you said?
The John's kid's mom.
Who's
Like my partner's
Oh, okay.
children's mother.
Okay.
He was coming over, and when she was over dropping the kids off, the kids were outside playing. He was yelling, "You need to learn to keep your legs closed. 3 baby daddies!" And in front of the kids, screaming that in front of Paige, screaming that, insulting both of us in front of our
On the
children.
cameras?
On the camera and in person when she
Okay.
was there. They said that they called the news because we required assistance over when the government shutdown happened in November, and we requested assistance. So they were on the cameras telling them, "Oh, we called the news because you're misusing whatever because you got assistance or whatever."
Wait,
Like,
how would they know
every
that you
single thing.
requested assistance?
Because they turned their camera to face our yard and only our yard, so they can see our front yard. So when the people came up to give us the assistance, they have it on camera. And they called on us 2 times since the plea deal. They called and they said that our dogs were barking consistently, and we pulled up all the footage, and 2 minutes of the entire day added together is how much our dogs barked. We had the back door open so they could go in and out of the house as they felt like, because it was 70-something degrees, it was nice. So they were coming in and out of the house and all together barked less than 2 minutes. The cops showed up at our house. Oh, they said that you're harassing them by letting your dogs out to bark all day. And then she called because the grass where our fence is, we have 4 inches behind, that's our property. They're not trimming it. So it's overgrowing. So I try to reach back there in our property in the 4 inches
Get
behind our
whatever's
fence
overgrowing
to try to cut it down. In 2 minutes after I did that, she was on the phone with the cops, calling them to say, she's trespassing, I want her arrested. She took 5 officers' time and 1 sergeant's time, demanding a sergeant come out and arrest me because I was trying to trim the weeds behind the fence. And we've been doing nothing. We're sitting there in silence in the house. We have not engaged aside from the pedo thing. We have been completely silent. They will not be able to show any footage of us doing anything. And the cat, I have been taking care of the cat. I had an appointment for the cat the next day to go get microchipped and veterinarian care. He saw me put out the traps because he has the cameras up.
Just a moment, please. You can travel. We'll be ready when we're ready. What's the matter? Oh, she's having trouble. Oh, that's a good. Oh, really? They can come up and down. Okay, sorry.
Last year in August, he told our cameras, he looked at our cameras after taking the live trap out of the yard. He looked at our cameras and he waved and he said, there's another dead cat. Now I can trap another one. And then as soon as he saw me put up the TNR traps for my cats to go get veterinarian care and get them microchipped, he hurried up and he armed his live trap and put it on directly on the other side of our fence where they eat. And my cat had been there every day for months, multiple times a day. And she went into
Is it
his
this
trap.
cat?
Yes.
But my understanding is this is not your cat.
I have been taking care of her. I food, shelter,
this is
and
not
I
your
had a
cat,
medical appointment. Yes, I consider her my cat. Her
No,
name is
not your
Callie.
consideration. You don't own the cat, ma'am?
I was microchipping it the next day. So the police
How can you
said,
microchip someone else's cat?
the police said that because I've been taking care of her, that she's considered mine. They have an open larceny case right now that they're investigating.
The open larceny?
Yes, because she's mine. I take care of her.
I don't understand how
And-
the larceny is connected to the cat.
Because they stole the cat. He took the cat, put her in the garage and never let her go. She's disappeared. She's never returned.
Oh, you're saying they have open larceny cat because of the cat?
Yes, because she was
But it does-
considered mine because I've been taking care of her for several months.
But the cat lives in the community.
She's an outdoor cat, but I take care of her. I feed her, I house her, and I had an appointment for medical care. That's what they consider owning a cat, or responsibility for the cat.
Well, I don't know, because if it's an outdoor cat, how do we know the cat doesn't have a home?
They check for a microchip and everything.
We don't have to microchip a cat.
Right.
What if the cat has a home and then during the day it's
Animal
roaming?
control says she's considered my cat because I've been taking care of her. I have food, shelter, housing, and I'm providing medical care for her.
But the cat doesn't live in your,
No, it doesn't have to live in a home in order to be considered mine if I'm taking care of it and providing medical.
but so then in the winter, the cat can live outside, is what you're saying?
Yeah. if
The
it wants
animal
to come
control told
inside,
you that.
yes. Yeah, I have a shelter that has heat inside of it.
In your yard
On
for the
front
cat?
porch. Yeah, on the front porch.
Oh,
There's a
so the
camera
cat
on
goes
top
in
of
there
it.
in the winter.
Yeah, and there's a camera on top of it.
So you do
I can
have,
watch.
you do have an indoor shelter for the cat?
Yeah, I
Okay.
provide shelter.
So you
food,
rescued
and-
the cat is what you're saying?
Yeah, and I've got 2 other cats that I rescued. One of them right now is inside the house. She had to have surgery when we got her from the TNR program. And I got them all medical care and I got them all fixed.
So if you
And-
own the cat, then you do know that the cat can't go on someone else's property.
Well, she's an outdoor cat. There's outdoor cats.
If it's
all over.
gonna be, if you're gonna take ownership, I don't have to let your cat be on my property if I don't want your cat on my property. You do know that?
No, I did.
Yeah.
So.
If you say it's yours, now you're responsible. If your cat come on my property and tear up my landscape bed, who do you think is responsible?
The cats have never.
No, I'm
come
asking, it's a
from me.
hypothetical.
Right.
Who
Then
would
it
you
would
think,
be- it would be me.
now you've now taken ownership
Right,
of
it
this
would be
cat?
me. Yes.
Yeah, so that's the concern that you have when you take ownership of something that you say you want to live outside. Well, now you're responsible when it's on other people's property and they don't have to, if they have a pool, hypothetically, they don't have to allow your cat to be drinking in their pool or whatever. Anything else that you want to share? Because I want to clarify, there is no victim blaming.
Yeah, I just heard a lot of, well, they did this and they did that, and it's because I'm a pedophile. It had nothing to do with any of his record or anything. We didn't even know his name when this.
And then because of the already
it was because
feud,
of his actions.
Then you did finally, because you got a complaint, then you finally got his name because
right.
Of, okay.
And so we didn't even know anything about him. We were trying so hard to just ignore him. And then it just escalated from there because we kept getting calls after calls after calls. And then he started coming into our yard and mowing into our yard. And he just.
Okay, but that's been addressed though, is my understanding. Yeah. Let me, because I do have to bring a jury up. I just want to understand, is there a meaningful avenue for you all to be neighborly next to each other?
I don't know, because I've asked officers to have conversations with him before and say, could you please let him know to, this or that. And they're like, he's just not getting, he's just not, like, we've tried and it's like talking to a wall. And that's why I said, I feel like he needs to have like a mental health evaluation to kind of like talk to him about, like, this is not neighborly. This is why this is wrong. Like, you think that this, if we are responding to what he is doing.
Okay, let me stop you and ask you a question. Do you think that there's a meaningful avenue for you to be a neighborly individual next to your neighbors? Okay. No, I said you. I'm talking about your actions. You're responsible over your actions. You're not responsible over anyone else's, and you can't control their actions. Can you be neighborly?
I tried.
The answer is no. He's not willing to be neighborly. You see, her answer wasn't like that.
Well,
she said.
But her actions.
Well, no, you're all right. You're a victim blaming.
No,
you pled guilty to stalking. She didn't. That is, if you can't be neighborly, if you can't say no, I can be neighborly. I can recognize that. Even though I have a pool there, it could be a concern that there's a bright light shining into my neighbor's bedrooms at midnight. I can be neighborly and turn that off. I can be neighborly and not mow into their property or maybe not trap their cat that I know that they're caring for because it's walking through my backyard. That's neighborly. I asked you if you could, you said no. Any additional allocution?
I'm just going to put on the record that I've talked to Chris about this before and asked Ross about this just now, but I'll put on the record, I will be the intermediary. I will take everybody out one night to dinner and we can sit down in a public place and hash this out. And if we can't work it out, we can't work it out. And it's my treat.
I try because to talk to mediators.
I don't want to be back here.
No, it's not even just being about being back here. It's just, we're supposed to be community, right? We live on the street together. We all pay taxes together. Hopefully we're all working and pouring into the system together. Why can't we share, even though we have differences, why can't we share community or be private? I live in a community, I mind my business. I did recently have someone ring my bell and ask me if I could turn the chirp off on my camera system. No, but I'm not. What I will do is I'll adjust the times that it's chirping to be neighborly, but I have a security measure for a reason, and it has nothing to do with you. Yeah, it just lets you know you're on my property.
And that's what I had when the one time that we have ever conversed, that's what I said. I never once came over and said, hey, dogs are barking, or hey, this is bothering us, or anything. They never came over. It was just police. We've never had any incidents before. Nobody had ever complained about the dogs. There's never been an issue. And all of a sudden, they move in and it's boom, 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 boom. And they're running their sirens to get the dogs to bark. They're doing all this stuff. And we're like,
well, everybody is not as animal friendly as you may be.
Right.
You sound like you are very animal friendly. And he sounds like he's not if he's trapping cats that walk through his backyard.
And we don't need to have a conversation to all like get along as friends. We're just trying to not interact. But when I'm getting called for trying to trim like the weeds and I'm getting police.
It's petty behavior now. I agree. I don't think they need to go to dinner. I don't think they need to go to dinner about anything that's petty. I think what needs to happen, to the credit of if the officer did say that your client is not willing to formulate his mindset that I need to be neighborly. And let's start over with a fresh slate. Moving forward. I'm not gonna call 911 because her dogs are barking. If her dogs are relentlessly barking, that's different. But put your hand down. We've had enough allocution now. But I'm not going to invoke law enforcement who should be out here fighting crime, okay? Because I don't want to hear a dog barking. And I'm not going to leave a light on that's beaming into their property late at night. I can't address his cameras and where they're directed. You can put your cameras wherever you feel like you need to put
I
your
only have
cameras.
an issue with the ones that he has directly at our house, that he literally turned it so that he.
I'm just like, listen, like the same person who came to ring my bell, which I didn't even answer, to ask me to turn my truck off, has one camera and it faces directly towards my house.
Right, and
I don't like
wasn't
it.
that he was
I don't like it,
following
but
me
you have the
around.
right in your property to put a camera wherever you want.
But if somebody's been following you to different residences, taking pictures
That's
of you,
different.
then you
That's
don't
different
want
than I
them
can't
having a
control
camera
where he
directly
puts
at
his
your house.
camera, is what I'm saying. I can't allow him to follow you, but I can't control where he puts his camera. He has the right to put a camera wherever he wants around his property if he believes, I would hope, for his security. I don't know why anyone else would pay for camera footage, to be honest. But you also have the right to protect, if you have windows, put the shades down when it gets dark so they can't see in there. I can't tell him you've got to move your cameras. I don't have the right or authority to do that. That would be like me telling you the same thing. You can't put a camera directing yourself towards his house, even though you may have a valid concern about your safety. And so you have the right to put your cameras wherever you want. And so I can't address the cameras. He's not allowed to follow you anywhere. That's ridiculous. And who's spending time following people? Like that's ridiculous. And if someone is following you, we in the court like to preserve evidence, and you've got cameras. You see someone following you, snap a picture of it. You call 911 because that would be ridiculous, and that would create a presumption of something bigger than just a neighborhood dispute. That you're going outside of your way to follow a neighbor somewhere.
To my other residents to take pictures of my.
And when and you saw him, wasn't he in his car when this happened?
Yeah, I have him on camera.
And that you have it on your camera, you're saying?
Yeah, I have it on my security cameras over there.
And then when he got there, what did he do?
Told the police, he's like, see, this is the other house, and he showed the police pictures.
You saw that video?
Yeah.
I think this is from a few years back.
No, it wasn't. It was literally last year. What are you talking about?
Okay, ridiculous.
Last summer.
But it's ridiculous. If obviously it's documented, what in the world are you following a neighbor for to their other house and then telling the police something's? I would agree something's off if you're doing that. There's something you would probably are a little crazy if you're doing that. You're following someone to another house and then videoing it or pictures and giving it to the police. Put your hand down. I'm done. I got to bring a jury up here. I think the recommendation is appropriate because anytime you can't control your behavior and the judge asks you, is there's a meaningful way for you all to come to resolution so you can live in peace in the property you pay for in this economy, and you tell me no, well then we have to supervise your peace then.
One thing I'd say with the recommendation and what you follow from it. I'd ask that you strike the alcohol and drug testing. Alcohol and drugs have never been an issue here. It's never been alleged that he's been drunk at night, walking around inebriated. He's had no issues on bond with it. There's no substance abuse allegations whatsoever. So I ask that that be stricken from any recommendation order.
I think even in the report, it indicates a concern about the defendant dialing back his remorse. And I don't think he can have remorse for his action. And I'm not saying that he doesn't have a reasonable position to take as it relates to anything that he believed he was wronged about, but we're here for your actions. And you're only to be accountable for your actions. And you've not shown me, even in my direct question to you, about how you can be neighborly. It's, you know what, yeah, Your Honor, maybe I won't just be calling the police on them. I'll instruct my wife not to have, comments back and forth, because what we should be trying to figure out is how everyone can be comfortable in their own community. That it's unreasonable. It's unreasonable. And so if you can't figure it out, then we'll navigate that for you. The order of the court, ma'am, and you can release yourself from the stand. Thank you. 90 days Ingham County Jail with credit for 2 days. Also spend 88 days upon successful completion of 14 months probation. While on probation, I'm going to continue the no contact order. With Melissa Andrus in this matter. We did receive a letter from someone else, but I believe was the plea firm to dismiss one.
Yeah, it was dismissed one and then a 10th on the other. And then we had a sentencing cap for 12 months probation.
Oh, 12 months is the sentencing cap. We won't go beyond that. I don't know. I hope it wouldn't be necessary. We go beyond if he violates, I can tell you that. And we won't hesitate with that, because if you can't be neighborly, then you need to go live on an island by yourself. That's just what we have to do. We can't figure out how we can work with each other. And I mean, all neighbors are not great. I have a neighbor to me that his property is always overgrown. I could easily make life hectic for him. I don't. Why is that beneficial? I have neighbor, I don't have any animals. I have all my neighbors have animals. Their dogs bark all the time. Cats walk through my property all the time. I could easily put up a trap and trap people's cats. I could easily call animal control and complain. That's not neighborly.
Against the law.
Excuse me?
It's not against the law to be that neighborly.
No, it's against the law to create the kind of interactions you're creating.
Well, they're creating.
And that's why you're here.
They're creating.
And you have yet to take any accountability for your actions. And so until you can take accountability, then you can see how you need to do your part to move in a different direction. But because you are not, and you think that you have the right to continue to do this action because of whatever they're doing, it's not going to fare well for you. That's the problem. I think your attorney has tried to explain that to you.
Yeah.
I'm sure he has. If he's willing to take everybody out to dinner on his expense after this case is over.
I asked him to.
Okay, so you're gonna take credit for that too.
I did. Ask him.
Mediation, break bread.
You
I
say,
suggested a pool party. You know,
I don't think they want to come to the pool.
I don't think so, but I suggested it.
I'm gonna order that he not possess alcohol, marijuana, or a controlled substance. He's not to use or possess a firearm, ammunition, or weapon of any kind. He is to maintain his employment and provide evidence of that. You're not to be at any bars or nightclubs. I am not going to require testing. So that will only become an issue if the police get called to your house and you're drunk or something to that effect. I'm just telling you how this could be coming in, because I'm not going to order testing because I'm not concerned about that. What I'm concerned about is, can you be neighborly? I'm not saying that you should allow yourself or your family to be abused if that's what you believe is happening. That's not what I'm saying. What I'm saying is you are in control of your actions, and you do not have to trap somebody's cat unless they're doing some damage to your property. You can shoe a cat.
I did not do that to cats.
I could believe that. I could absolutely believe that.
Am I gonna get a cat in my trap?
If it goes in there.
Absolutely.
If it goes in there,
I
but I
can't
think the
control the
allegation is
cat.
that you kept the cat after that, which I don't.
No, we
believe.
let it go.
Okay.
So.
And even to your credit, I think that at this point, because of the nature of the behavior, everyone is ultra sensitive to everything that's being done. And that goes to you too, ma'am. You have to not be ultra sensitive about everything. Everything is not an attack on you. Every time you see the light on his camera doesn't mean you can decide that he's watching you. You don't have a clue who's doing what on their phone.
Well, when they come on my property, then that is against.
Did I ask you to keep talking while I'm talking? Did I not? It should not take me an hour to sentence you. I am explaining to the neighbor that she tried to be neighborly, which she said she could. And the thing is, you don't know what someone is, always know what someone's doing, just because it may be perceived that way. You may think that the camera's in your direction, but it might not be. It might be in also picking up the flow to his windows that are over there. I don't know, but don't always assume that everything is about them being out to get you. And so, but if you're trying to mow your lawn or get the overgrown and then the police show up, I think it's safe to assume this is about you.
That's not being neighborly either, because the neighborly person would make sure their stuff isn't overgrown onto their neighbor's stuff. That's first. That's what a neighborly person, you don't have to worry about trimming or on my side because I'm gonna take care of it for you. So everyone needs to do their part, but you're required to do your part because you're under court supervision. And so I am gonna order anger management.
I already did that.
You'll do it again. Talk over me again. I'm not your neighbor. You'll do anger management and provide evidence of that. I'm gonna write again because I think you have a lack of control over your mouth.
I have the right to say what I want on my property.
You are not in your, this is my property right here. You don't have the right to say what you want when I'm sentencing you. And when I tell you to stop talking over me, you take this stance and you bend your knee and you put your hand in your pocket and tell me what you have the right to say, I have the right to give you 90 days in jail right now, plus a contempt. Because I've already ordered you to stop talking while I'm trying to sentence you. This is not your property. This is a courtroom of law. There will be order. I've given more than ample time for everyone to get their words out. Even when the prosecutor objected, no, I'm letting everybody have their moment. But when it's time to stop, you have to be in control of your mouth. You have a mouthpiece. Okay? Thank you. Again, anger management group, you'll provide evidence that you've completed that to the probation officer. And check the wrong thing. You'll provide evidence of your employment. There's a $30 per month oversight fee for each month of probation. That's $360, $75 crime victim rights fee, $50 state minimum costs. I'll waive discretionary fines and costs at this time. Any additional matters for the record?
Nothing on behalf of people.
No, Your Honor.
He's got to go check in with probation. Did I give you too many files? I might have.
Yeah.
Thank you. Okay, we've got to bring the jury up and pick a jury so that they can then go to Buchanan.
Thank you.
You're all set, thank you.
Oh, Judge, I know that the fence is on the property. Can they fix the fence at this point? Fine condition. Okay.
I'm sorry?
We just
We're
sorted
good.
it out, Your Honor.
Oh,
We're
good. See,
being
we're
neighborly.
neighborly.
We're doing it.
Thank you.
Can I
think-
grab some belongings from the jury room?
Please, I think everybody wants their property fixed.
After I take him down, you will wait a jury.
Correct.
I got you.
That's fine. I can do it.
Perfect. It's a hot stinking mess.
Inside our fence, the dogs don't jump on our.
We got it. We're good.
Best wishes to you, sir. Best wishes to you, ma'am. So we're gonna pick a jury. We're gonna send the jury to lunch and then we'll finish the morning doc. You have just enough time for him to bring the jury up.
Hurry up.
Can we set mine for the other day?
Yes. You're here with Isaac.
In all candor, he's not here.
And who? Who's not here?
My client. I don't want to.
Ezekiel. I said Isaac. Ezekiel,
Yeah.
okay.
I don't want to misrepresent.
Have you had contact with him?
I had contact with his father. There was a little bit of a mix-up. We thought this case was going to get dismissed and he'd go through diversion. And I think you may have taken it off the schedule because of that.
Okay. Give me a plea date. August 11th at 10:30. August 11th at 10:30. What was going on with Taylor, with Trisha Taylor? And
Thank you.
no problem. And Erica Dietz.
I'm via Zoom. I am here.
Where I'm asking your attorney or what's going on. Who's having trial? Let's see here. Is it James? This is- Boy, is this a projector? What is this? Oh, I mean, the other, oh, that was just a thing.
It's just a stand.
I thought you were bringing a projector. Oh, boy.
No. Don't have to worry about the echo. I just need some speakers.
Taylor and Dietz are both Jessica's clients.
To the intern, he's not helping anymore.
I'm not sure where
No.
the. As well. Also, I'm curious, so I have Ms. Lazan and Mr. Antonio Whiting here. I'm curious.
I said I'm gonna pick a jury, then I'll finish with the docket.
Okay.
What's Whiting doing? Final pre-trial?
Yes.
But we can just give him a date and he can keep it moving.
Okay.
We'll give you the date. Sorry? You can come up, that's fine. He's gonna get a final pre-trial. I'm assuming there's no offer at this time, so. August 11th. August 11th, 8 AM for a final pre-trial, okay? And then jury trial. September 29th at 8. September 29th at 8 AM in person, okay? We'll get you a notice in just a moment, okay? Thank you.
So usually we'll get you a notice.
Who's Mr. Davis? Is in custody?
In custody, Your Honor.
Got it. Does he know he has to bring an offender? I think you just sent him to probation. Did he just go to probation? No, the defendant for this trial. Yeah, I know, I'm talking about. David. Oh, yeah, he said he was gonna bring up the jury. I'm like, you gotta.
They don't know about the jokes.
You gotta bring up the jury, I mean, the defendant first.
It's a.
Somebody is right here. Maybe you can have.
George. the language in the complaint. We discussed last time how the statute, the ordinance cited, the language in the complaint does not align with the ordinance. The ordinance basically says you're guilty if your dog bites another dog. I believe this was issued on I believe there is an affidavit of probable cause in this case, and the affidavit would support the change in the charging edge. I imagine the affidavit would say that there was a dog bite. Otherwise, we can dismiss and reissue.
You said the affidavit would say there was a dog bite.
Yeah, I haven't seen the affidavit of probable cause. I just assume that if it doesn't say that, then we can dismiss and reissue.
Oh, yeah, alleged that one dog bit part of another dog's ear off. Through a fence.
So the complaint does cite the correct ordinance. I would just ask the court's permission to file an amended complaint that uses the language from that ordinance instead of the language in it.
You're gonna amend it to cite the language of the ordinance, did you say?
Yes.
That's fine.
Okay, thank you.
Let's see. And you want a jury trial or a non-jury trial? Sir,
Non-jury trial.
I think we're fine with that trial.
set for bench trial. You do September 29th at 9. They're gonna move it up a little quicker. September 29th at 9. You said at 9? Yeah, okay, at 9. Okay. Any other matters for the record?
Nothing.
I previously requested, I previously submitted motions, and I know we talked about the motion in limine was potentially a further trial, but the reason why, I guess the question or statement I have is that kind of calls into question their only witness. And without that, I question if there's enough evidence to proceed to trial. That's why the motion to.
Your motion to eliminate, is to eliminate what? The testimony of their only witness?
Yes.
Based on what?
That he didn't see, his own testimony states he was not.
Well, that just goes to the credibility of the witness. If they didn't see it, but we can't eliminate the witness's testimony just because they weren't an eyewitness. Yeah, so I mean, they don't have an eyewitness. I mean, that's the weight of their case. Maybe they don't have enough evidence to prove the case beyond a reasonable doubt, but they do have enough to bring a case to court. And you can't eliminate that witness just because they weren't an eyewitness. Yeah, no problem.
In an effort to be neighborly, there was an attempt to settle this, but unfortunately, there was no neighborly response.
He's a defense attorney.
He got the thumbs up.
Okay, we'll get you a notice and you'll be all set. How about September 29th?
Thank you, John.
Oh, $200. I'm getting too much better. I we saw me, yeah. I was like, then started laughing. I was make cases. So Mr. 14 might not be able to say it. When you go to John.
Oh, yeah. No. I had to get shown this by Yara. She had some of this stuff. It's so complicated. You spread it out like this, and these little guys actually hang on these things. And you set it down on that. No, Yara gets credit. She figured it out. That's the thing. And then you can like move this. You can screw these up and move it out and like pinch it there. The bottom. You can like slide that and pinch it to the thing. And then you just need to adjust. the
She's
distance.
trying to go to on a girls trip. You gotta travel on your budget. I told her this already. You travel on your budget, not mine. A girls trip to New York.
Okay.
Oh, yeah.
you would like to request additional discovery, Your Honor.
Okay, and what about the Latricia Taylor?
Ms. Taylor just needs another court date, Your Honor, because we're really in the process of getting her case transferred over to sobriety court. We worked on mental health court.
Let's just get you the dates, because we got stuff. Ms. Deeds?
August 18th at 8:30.
August 18th, 8:30. Ms. Deeds, can you hear me?
Yes, I can.
Your matter is rescheduled for August 18th at 8:30, okay?
My matter has just been rescheduled, you said?
That's what your attorney said you wanted. There's additional discovery that she's requesting.
Okay, I was actually going to ask to speak to you, Your Honor, in regards to asking for new representation, new counsel, and in regards to a continuance as well.
You can file a motion for new attorney if you want me to consider it.
Okay, thank you, ma'am.
You're welcome. Okay, Latricia Taylor? Sorry?
We're asking about the jury, but I'm saying just a second. I don't know if they're ready.
Oh, the jury
And they
here?
were all set.
They can come. Latricia Taylor, the jury can come in.
I hear you.
Yes, your matter was rescheduled August 18th at 8:30, while your attorney is working to get your matter transferred, I believe. Is that so? Okay.
Okay, August 18th at 8:30 a.m.
Yes,
Okay, I got it.
thank you.
Your Honor,
Thank
I
you.
have
Have a good day.
Jana Wallace.
Okay, and then we didn't see Miguel Julian, correct?
No, and I believe the construction home says we do not have a phone number.
Okay, so that's what they said to him. Oh, that's our morning docket then. Very good. Lampier, I have this file, I don't know what I'm supposed to be doing with it.
We saw it cut Korea and design that we were gonna do that.
Lazan?
Yeah.
Oh, okay, is that the one in the wheelchair?
Yes.
I don't know what, oh, that might be the file right here. Okay, we'll do that after I send the jury to. Yes.
All rise.
Okay, let me get some of you all in the jury box. Juror number one, Feliciana Garcia. You can come around this way. Juror number two, Silvana Banks. Is Silvana Banks here? Okay, very good. Okay, Kevin Scobie. Who's Kevin Scobie? Okay. Colin John Waybrett. Samuel Fitzgerald.
Here.
That's number 5. And number 6, Bradley Richmond. 7, Sophie Moss. Okay, there should be more room now for you all to stretch out and have a seat. And you may be seated. It's been a day. Praise the Lord. Let's see. Council. Come around. Okay, ladies and gentlemen, both in the jury box and those of you waiting for a potential chance to be in the jury box, you can affix your attention towards the screen. We have some preliminary instructions. Ladies and gentlemen, I am Judge Kristen D. Simmons, and it is my privilege and pleasure to welcome you to the 54A District Court in Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and a prosecution have a right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not take it personally. If you are excused, I have explained already that it simply may be something that causes you to be excused in this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking the oath, you may instead affirm that you will answer all the questions truthfully, fully, and honestly. Please all rise and raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, you signify by saying, "I do." I do. Thank you. You can have a seat.
I'm going to introduce my court staff. To my right is Miss Addie Nash, that is my judicial assistant and court reporter. To my left, the person who escorted you up is my court officer, that is Mr. David Warrensley. This is a criminal case involving, it should be one count of the charge of domestic violence, and I will explain that more fully later. This charge has been made against a defendant named Jalen Davis. The defendant's attorney's name is Jessica Straub. Ms. Straub, if you could please stand and list any witnesses you anticipate calling at trial, and introduce yourself.
Hello, everyone. My name is Jessica Straub. I am representing Mr. Jalen Davis today. I intend at this point to call Mr. Seth Otzentowski.
Assistant prosecuting attorney is Mr. Ross Marchmina. Mr. Marchmina, please introduce yourself and list any witnesses you anticipate calling.
Hello, everyone. As the judge noted, my name is Ross Marchmina. I'm a prosecuting attorney here in Union County. We intend to call Officer Lydia Chapello and Detective Sarah Wilson, along with Eugene Fraser and ideally Ms. Sapphire. Thank you.
Does anyone in the jury box or anyone waiting to be chosen to get into the jury box know the defendant? If you know the defendant, please raise your hands. Does anyone know any of the lawyers that just introduced themselves? Anyone recognize the names of those witnesses at all? You do? Which one?
Sarah Wilson.
How do you know Sarah Wilson?
Works as a detective in the case that I was involved in.
She works as a detective in a case that you were involved in? Okay. We think that this trial will last for 1 day, meaning we should be able to complete this today. If you believe that the length of trial will be a real hardship for you, please raise your hand. Some of you may have health problems that will prevent you from serving on a jury. For example, does anyone have any medical problems that make you unable to sit for 2 or 3 hours at a time? We don't sit for 2 or 3 hours at a time. Yes.
For knee replacement, I was wondering, could I sit down here so I don't be so crowded here?
Unfortunately, you cannot sit down there because the prosecutor and his witnesses may sit there. As you can see, it's a very small courtroom. If you are going to be selected, we can figure out how we can rearrange it if he's not going to have a witness there, okay? But we will not sit for 3 hours at a time. I try to take a break at each hour, okay? Does anybody have any problems hearing me? If you can hear me, raise your hands. Everyone's hand is up. Very good. There was a time we were selecting the jury, or I watched someone selecting the jury, I think over there, because I had the jury earlier that week, and there was someone hearing impaired. But over there, they sat the whole time and couldn't hear anything. So I want to make sure everybody can hear. That's a small courtroom. Can everyone see us clearly or see up here? Okay, this is a criminal charge, a criminal case. The paper used to charge a defendant with a crime is called a complaint. The complaint in this case, this needs to be edited, charges the defendant Jalen Davis with 1 count of domestic violence. And it reads as follows. That order about October 30th, 2025 at 6203 Grovenberg Road, Lansing, Michigan, that the defendant did allegedly make an assault or assault and battery upon a Sapphire Passion font or fence, an individual with whom he had a dating relationship, and that this was contrary to Michigan Compiled Law 750.812. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal charge or trial so that the defendant and the jury can hear the charges. You must not think that it is evidence that he is of his guilt or that he must be guilty because he has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty.
A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. You can proceed.
Okay, thank you all so much for being here. It's obviously just a beautiful day outside and you're here in this tiny hot courtroom. Not anyone's ideal way to spend their time, but it's an important civic duty and I really appreciate that you're all here. The purpose of this part of the trial is for the attorneys here, myself and the defendant, to make sure that we have jurors who are the right fit for this case. Okay, because everyone has biases and experience that might make them not the right fit for any given jury. Does anyone have any questions about this process? No? Okay. Now, juror number 2, I'm gonna start here. You indicated that you have had interactions with Sarah Wilson. Is that, I take that to mean were you the victim of a domestic assault?
No, it was more like a case of body, like my child.
Okay. So was it a domestic assault case?
No, it was more my ex-partner said something appropriate to my daughter. So I got CPS involved, which she was involved in.
Okay, so it didn't involve violence per se, it involved inappropriate behavior with domestic chat. Now, what kind of interaction do you have with Sarah Wilson?
She was a detective on the case, so I met her maybe 2 or 3 times.
And how much time did you spend with her when you had?
Majority of my daughter.
So if Sarah Wilson is sitting up there testifying, how would that impact you?
Personally, I don't like how the case was.
Who do you view as the person of people who dropped the ball? You think Sarah dropped the ball?
Correct.
Now with her sitting there, is that gonna cause you to believe in this case probably got funded too? So it's possible that you're not sure. Hearing that Sarah Wilson is going to be a witness today, does that sort of impact your starting point as far as whether or not now getting into a little more, who here by a show of hands has heard that defendants have the right to face their accuser? Who has heard that before? You guys have heard that? Got 3 people. Let's pick on juror number 6. What does that mean when someone says the defendant has the right to face their accuser?
Frankly, I think you have the right to question somebody who makes accusations against you.
Okay. Juror number 7, how do you feel about?
Yeah, I kind of agree with what he said. I haven't really heard it in the context other than so I don't really know much what it means.
Would it surprise any of you to learn that there actually is no constitutional right to face your accuser? Would it surprise any of you to know that that's not in the Constitution? Well, the Constitution says that a defendant, quote, has the right to be confronted with the witnesses against it. What that means is that any witnesses that we call, anyone who is testifying against this individual has the right to ask that person questions. Right? Does that make sense to everybody? Does anybody have any questions about that? Okay. Now I'm going to pick on juror number 5. Juror 5, who is the accuser in this case? Who is bringing this case against Juror Davis?
The city, the state.
It's the state. That's right. That's exactly right. Does everybody here understand that it is the state of Michigan versus Jalen Davis? It is not a person bringing a case against Jalen Davis. Does everyone understand that? Juror one, do you understand that? What does it mean when I say it is the state of Michigan bringing a case against Jalen Davis? Yeah, when I say there's no person bringing a case against Jalen Davis, it is the state of Michigan bringing charges against him. What does that mean? Not sure what that means. What that means, juror number one, you don't have to name your number now. What that means is that people, attorneys like me, who work for the state, who work for the government, review the evidence that exists against Jalen Davis, and we made the decision on behalf of the community to bring criminal charges against Jalen Davis. Ours should be elected. And we are the ones who are bringing these charges against him, not any individual person. Does that make sense? Juror two, does that make sense to you? Juror three, does that make sense to you?
Yes.
Yes. Juror four, does that make sense to you? Juror five, how about you? Yes. Juror six?
Yes.
And juror seven? Now. We're going to, I guess one last thing, you know, I mentioned this Sapphire Font. She is the person we are alleging to be the victim of this assault. I said, hopefully, ideally, I at this point have no reason to believe she is going to be here and testify to you. I don't believe that you are going to see her in person at all. Juror number four, do you understand that I have no obligation to produce a victim? You understand that? Do you have any questions about that? Are you going to be willing to find Jalen Davis guilty, even if you never hear from the person I'm claiming to be the victim? Juror number five, does that make sense to you? I do not have the burden to produce a victim. How do you feel about that? Do you think I should be required to bring the victim into court?
I think it would bring nuance and details, more information, but I don't think it's a requirement to make a decision necessarily.
And do you believe that you're capable of being convinced beyond a reasonable doubt that Jalen Davis is guilty if you never lay eyes upon the person you claim to be the victim of this assault?
With sufficient evidence, yes.
Juror number six, do you understand that I have no obligation to produce a victim? Do you have any questions about that?
Yep.
Are you willing to find Jalen Davis guilty, even if you never hear from the victim in this case?
Yep, it supports. Yeah, you can prove beyond a reasonable doubt that the elements of the crime were met, but the victim's present, I don't think matters.
Her absence from the trial, do you believe that is evidence?
I don't know.
You don't know. Do you think that you might find yourself saying, well, if he was guilty, she would come to court and testify? Is that a thought process you might entertain?
No.
No? Okay. I'm going to skip back there, Juror three. He's shaking his head. Is that a thought process you would entertain?
Yeah, I didn't think about it.
You have to think about it. Sitting here now, do you think that you would be willing to find Jalen Davis guilty, even though I most likely will not be the victim in this case?
If law, say he's guilty beyond reasonable doubt, yeah.
Do you think that you would be in the jury room saying, well, if Jalen Davis was guilty, the victim would have come and testified? Do you think that thought? Probably not. Juror number seven, do you understand that I don't have a duty to produce a victim? And would that keep you from finding Jalen Davis guilty?
No.
Juror number one, do you understand that I have no obligation to produce a victim? Yes, you understand that. We always have to tell the witnesses, you need to say yes or no, because Ms. Nash can't type anything. And would, if I do not produce a victim in this case, would that stop you from finding Jalen Davis guilty? You have to look at the evidence. Is it possible for you to be convinced beyond a reasonable doubt that he is guilty, even if Sapphire Font never sits there, you never see her? Do you believe that it is possible for you, juror number one, to be convinced beyond a reasonable doubt that Jalen Davis is guilty of assaulting Sapphire Font, even if Sapphire Font never sets foot this place? Yes. Are you only saying that because you think that's what I want to hear?
No.
Okay. Do do you think that her not being here, is that evidence that Jalen Davis is innocent? You're not sure? Okay. Let me put it this way. Do you think that you can see yourself being in a jury room and saying, well, if Jalen Davis was guilty, Sapphire would have come to court? Do you think that you would find yourself saying that? No. Now, juror number 2, do you understand that I have no obligation to produce a victim? Yes. And is that something that would keep you from finding Jalen Davis guilty? Now, we're going to start. Remember where I started? I always do that. I'm going to start here with juror number 5. Juror number 5, do you have any experience with domestic violence? No. No? Do you have any friends who have any experience with domestic violence? Okay. Can you think of any reasons why someone who has been assaulted by a significant other might not come to court to testify? Yeah. What are some reasons?
It's traumatizing to be forced to confront that experience again, seeing the evidence again, the memories. It's
So being re-traumatized, something that might keep someone.
Yeah.
Okay, juror 6, do you have any experience with domestic violence?
No, sir.
Do you have any friends or relatives you know of who have experience?
No, sir.
And what reasons can you think of there might be for someone who is assaulted by a significant other to not come to court?
Lots of reasons.
Give me one.
It's inconvenient.
Okay. What's another one?
Fear of public speaking, fear of cross-examination.
Good. Juror number 7, do you have any experience with domestic violence?
No.
Do you have any friends, family, anyone who has experience with domestic violence?
No, I had a coworker at one time, other than, a kind of troublesome situation, confided in me, but that was about it.
So coworker confided, what did the coworker confide in you?
They were in what they refer to as an abusive relationship, and they were talking to me about it, and then they both played certain point, so I heard a little bit about what that process was like for them, but this was just an old coworker.
Okay. Did you believe that she was telling you? Yeah.
I had no reason to think she was lying about it.
Okay. Why do you say she had no reason for it?
I don't really think that that's something that people would want to know, but, I'm not in her head, so.
Did she continue to stay with him even though she was being abused?
I believe so. We weren't that close. I just saw her at work, but I believe she did. I'm not really sure.
Do you have any idea why she did, even though she was being abused?
No, I don't know. I'm sure, in the same reason you showed at work, there's probably a lot of reasons. Fear, maybe based on them.
Fear of what?
Maybe retaliation, or if you believe more violence or anything like that.
And juror number 1, do you have any experience with domestic violence? Do you have any friends, family, anyone you know? Can you think of a reason why someone who was assaulted by a significant other would not come to court? Scary? What would be scary about it? Okay, so having to be in the room with them would be frightening enough to keep it. Juror number 2, obviously we talked a little bit about what happened with your child. Do you have any other sort of experience with domestic violence?
Yes, I'm 16.
Was it, were you in a relationship? Okay, I'm really sorry for that. I appreciate you being forthcoming about that. Do you know of, we'll just take a step back. That right there, how would that affect you? Your relationship?
Yeah.
How would it be difficult?
Hearing testimony.
Would it sort of teach different for you? Would you, I always hate making it out. I always hate when people are really honest stuff and you get them to this kind of question. It's not lost on me for sharing something that's really horrible. I have to ask, would you be able to focus on the kids having this trigger? Something you kind of can't know. Well, thank you very much for sharing. Juror number 3, do you have any experience with domestic violence?
It's been a while, but really got poked in his eye and turned around and busted his girlfriend's nose. That was all about. She got a nose busted. She doesn't have a baseball bat. So
Okay. How do you feel about that situation?
it was crazy.
Yeah. That sounds like a good situation.
Just one day in the neighborhood, you know, Mr. Hodges didn't compare me to my neighborhood.
Okay.
I come from the country and I live in the Southlands.
Okay. Understood. Now, juror number 4, do you have any experience with domestic violence?
Yes, I have some family members, who were, to my knowledge, victims of domestic violence, but then left the relationship, and essentially married, one of them didn't remarry, one of them did. Some friends that I know of who,
So it sounds like there were 2 people in your family?
yes,
And who were they being abused by?
their spouse.
Do you know how long they were being abused by this family?
I do not, I was young at the time, it was, my mother's godchild, that, my family, that was very much the time. And something that my family didn't really talk about at first time.
And I guess how would that affect you being here today with domestic violence?
I think that I would be able to put my own personal experience and the experience of my family members aside, and actually be honest. I think Kristen said that everyone guilt has to be proven beyond a reasonable doubt. And I can really I can't follow my personal experience with influence or interview with that.
A little bit about my burden in this case. My burden is to prove the elements beyond a reasonable doubt. It's not my burden to prove the exact details of what happened. Right, so I have to prove that Jalen Davis had at some point a relationship with Sapphire Pond. I need to prove that he intentionally initiated a violent, harmful, or offensive contact. Right, I don't need to prove why he did that. I don't need to prove, what exactly he did. I don't need to prove how long this lasted. Does that make sense to everybody? Juror number 6, are you able to focus on the elements rather than the details?
I am.
Do you think that you'd be able to find Mr. Davis guilty even if you don't know exactly what happened?
It's hard to speculate without knowing the evidence.
Okay, that makes sense. Do you think it's possible for you to be convinced of the elements?
Certainly.
Even if you don't know exactly what happened?
Yes.
Like, for example, I like comparing to homicide, right? Because how often do we know exactly what happened in a murder? We can infer that someone was murdered because, there's a person on the ground with a bullet in their head. And so we can put together, okay, they got murdered. We don't know what the shooter said. We don't know, stuff like that, right? But we can know, okay, a homicide happened. And now let's get to figure out who did it. Does that make sense? Even though people have trouble applying that logic outside of it. Does that sort of logic make sense?
Yes, I understand the point.
Okay. Juror number 7. Do you understand that my burden is the elements, not the exact details? Are you okay with reaching a guilty verdict, not knowing exactly what happened?
Yeah, depending on the evidence.
Obviously, I have to meet my burden. You feel okay about it. Juror number 1, do you understand my burden is to prove the elements, not the details? And do you believe you're capable of reaching a guilty verdict without knowing exactly what happened? Yes. Juror number 2, Do you understand that my burden is the element of do you think that you're capable of reaching a guilty verdict without knowing exactly what happened? Juror number 3, do you understand that my burden is to prove the elements other than details? Yes. Do you think that you're capable of reaching a guilty verdict without knowing exactly what happened? You do your best, but you're not certain. Yeah. Okay. Now, juror number 4, do you understand that my burden is the elements on details? Do you believe you're capable of finding the defendant guilty even if you don't know exactly what happened? And finally, juror number 5, same question. Do you understand that my burden is the elements not details?
I do. Can I make, express one concern?
Absolutely.
The presentation is having us focus on the facts rather than the details, but then we were given an example about murder, which I think starts to infer a certain level of guilt that's related to the detail that's not relevant.
Maybe it was a bad example. Exactly. Maybe not the best example. I think that the point I was trying to make is that we can prove the crime happened without knowing exactly how it happened. Does that make sense to you?
Yes.
You know, like for example, no, I won't give another example because I clearly didn't know. Do you have any questions or other questions or other thoughts? Does anybody else have any questions or thoughts or concerns about what I've been talking about? Now, I'll start my last question. Juror number 7, what's the difference between self-defense and retaliation?
I think the intention, retaliation would be you were doing something, not because you want to, isn't the right word, but self-defense is, to me, not something you're initiating, you're doing it because something is happening to you, maybe, so it's a reaction, not something you are initiating. It's how I would define it. If that makes sense.
Juror number 1, what's the difference between self-defense and retaliation? Juror number 2, what's the difference between self-defense and retaliation?
She doesn't speak up. We have a lot of fans going on, so if you can speak up a little bit.
In self-defense, you're defending yourself against the aggressor.
What is retaliation?
Retaliation is actually
Your question was, what is retaliation?
Yes.
Okay, this is not a vocabulary quiz. You don't know, you don't have to know.
Okay.
We gotta give.
Let me give you an example, right? So like, let's say someone hits me and then I get mad and I hit them back. Would that be self-defense or retaliation?
oh no, that's retaliation.
Okay. Juror number 3, what's the difference between self-defense and retaliation?
Self-defense, when I can defend myself. Retaliation, when somebody gets the justice they might deserve for doing something.
Okay. Now, juror number 4, what's the difference between self-defense and retaliation?
Self-defense is more that you have a reasonable assumption of bodily harm or death from what's taking place. Whereas retaliation, the standard is different in terms of like there's less of a.
I guess, would you agree it's okay to keep yourself safe, but it's not okay to like get someone back?
Yes.
Juror number 5, what's the difference between self-defense and retaliation?
Self-defense is the way that you protect yourself as you endure some kind of aggression. Where retaliation, you're adding to the conflict either for emotional or ethical reasons. It's not about at that point keeping yourself safe.
And finally, juror number 6, what's the difference between self-defense and retaliation?
I think self-defense is taking reasonable steps to prevent yourself from imminent or future harm. Whereas retaliation is vengeful, it's conducting yourself in a way to get someone back for their prior conduct.
Thank you all so much. That's all the questions that I have. I'll turn it over to the defense now.
Hello again, everyone. I have so much here. I want to kind of start out with the presumption of innocence as it stands right now. Is Mr. Davis guilty or innocent? Oh, sorry. Yes, right now. You agree? Okay. What about you?
Presumed innocent.
Okay. Innocent.
He's innocent.
What do you think? And who carries the burden of proof today? Feel free to just jump in. You, yes. And what is that burden of proof? Beyond a reasonable doubt. And so if you had to break down what that means, beyond a reasonable doubt, what would that mean? Is it a maybe? Is it a very
No,
likely? You gotta be sure. Okay. What do you think?
It means that there is no other likely explanation for what occurred.
I think for me, the punishment or whatever it is focused on what there's proof for. So it's just an assessment of the facts. The facts have a logical conclusion to them about what happened or what part of something happens. That's really one you can trial on.
Okay, so probably? Is that what you're saying, probably?
So I think in any kind of case, there's multiple elements to it, right? You can prove A, but there's not enough evidence for B, and that can adjust what the verdict is. Like sometimes you start with one claim of this is what the charge is, and you adjust it based off of what there's sufficient evidence for. But if there's no evidence for any of the parts of the claim, then
Okay, so essentially you've got to be convinced. Okay. What if I said that the defense could sit at the defense table today and we could play Go Fish with one another, and that would be perfectly reasonable under the eyes of the law? What would you say about that? You kind of smiled.
I don't know that it would add a lot of value to maybe your defense, but I'm sure you could play Go Fish.
What if I told you that's literally the law? The law said I don't have to do anything. And that's the law. Okay. And would you be able to follow that law? Yeah. Fairly and impartially? All right. What about you? Okay. Juror number one, what do you think? I'm just sitting over there. We're playing Go Fish. What do you think about that? You don't know? Okay. Juror number one, you have an opinion? Oh, I'm sorry. You're right.
So if you're just sitting there playing Go Fish, I feel like that was weird for you to.
That might look a little silly.
Yeah.
But would that be against the law?
No.
No, right? I don't have the burden of proof, right? All right. What do you know about the Fifth Amendment right to silence? You might have an opinion. You've been pretty spot on today in terms of like explaining certain legal concepts. What do you?
I think that you have a right to remain silent and that nothing can be inferred from your silence.
Okay. So then if the defendant, right, if Mr. Davis does not take the stand, can you use that against him? Can we use that against him if he doesn't take the stand today?
I guess the evidence would prove, anyway, whether it comes out of his mouth, where we get the evidence from.
Okay, so if he doesn't take the stand today, are you gonna be able to find him innocent?
Yeah.
If they
Oh,
don't.
yeah,
Okay,
definitely.
okay. What about you, Jerry?
Sorry.
Absolutely. Would you be able to find Mr. Davis innocent today if he does not take the stand?
Yes.
What about you? Even if I'm playing both fishes. All right, tell me some reasons why a person might not take this stand.
I asked, are you a public defender?
I am an attorney, I'm a defense attorney. Okay. What if I told you that he might actually not take this? And tell me some reasons why that might be. Like if you had to come up with some logical reasons why a person might not take the stand in their own defense, at their own trial, what would you think? That's a really good one. Can you say that just a little louder? Anxiety. Yeah, okay. Anybody else got any thoughts?
To have the best case, you have to be well spoken. I know if it was me up there, I would be rambling and babbling. I would very much appreciate someone who could speak my thoughts and feelings on my behalf.
Even the people who go through training, right? Like holding my arm up here. This is nerve-wracking, y'all. This is not easy to do. This is hard. Okay. So yeah, anxiety. Might not feel like you're the best, most well-spoken person to do the job. Okay. Any other thoughts? What about the fear of subsequent litigation, right? Like what if they're worried that they could be sued at a later time? Is that fair?
If you get sued?
Not you, but a person, if they're found guilty, potentially, and then if they get up here and take a stand and say things, maybe, right? What about if I told them that he shouldn't? You think that's a legitimate reason to not take a stand is if your attorney tells you not to? What about fear of cross-examination? Right? Because again, right, this is a little nerve-wracking. And one of the biggest fears that people have in the world is what? Public speaking. Right? And then you get up here and you start doing what you said, right? Stumbling all over your words, and now your meaning isn't really coming out the way you want it to, right? The cross-examination is imminent. Right? Why do you think someone might report a crime to police and then later on refuse to cooperate in the investigation and prosecution of that case? I'm sorry. Yes.
They are scared, or it's come traumatic to put it again. Someone is from a marginalized and minority community in hospital that's they might have distrust of the justice system, and that might anxiety.
What about you, sir? What are some reasons that a person might file a claim with the police but then not want to cooperate in the investigation or prosecution?
Because there's always charges.
Okay. All right. And why would that be a basis for them not to proceed?
Well, he's not guilty, right?
Okay, so they pull out of the prosecution process because you're nervous or?
Every case is different, probably.
Okay. Anybody else got any ideas for why somebody might not proceed? You ever been in an argument with somebody and maybe said things that you didn't mean, or you felt like you overreacted? Never?
Not very often.
I'm very impressed.
I say what I think.
Yeah. Okay, so you never regret
Say
saying
anything?
something in the heat of the moment?
I'm silent, so I stay by myself.
Okay. Okay. What about you?
I'm sure I have, like, said things I don't mean, but I feel like I'm pretty quick to take that back and have a conflict resolution conversation. So, yeah.
It's hard to take something back.
Yeah, especially if the police get involved, huh? Okay. What if the person admitted to law enforcement that they initiated crime? That they hit somebody's first? Why then might they not proceed to trial? What you thinking?
Thinking that maybe in domestic situations, it's scary to think about. You can't control the circumstance, you can't control the outcome. The person on the other side is someone that you care about, that have an initial heated interaction, and then once cooler heads prevail, you realize that what's done is sufficient and you want to be done and over with it.
The person who makes that type of statement to police that they potentially get in trouble?
Sure.
What is more troubling to you? That an innocent person be convicted of a crime, or that a guilty person be acquitted? What about you, Jen?
I think that acquitted gets more attention because a lot of our politics and stuff, people are more exposed to those stories in the news. But at the end of the day, it's when you're innocent and you're charged anyway, that's really upsetting.
That's troubling.
Following that with plan the couple of more regardless of what prior experiences might have been.
You don't agree with me?
That
What's more troubling? Sir?
was the question.
My question is, what is more troubling? For an innocent person to be found guilty, or for a guilty person to be acquitted?
Can I say both?
You could, but I'm
Because
asking you, I'm
sometimes
asking you to
I got a
choose.
friend that he didn't have the best representation, being a public defender, and he got really hung. That's why I'm asking for a public defender. I guess you can do something, but you still got involved with it, right?
I do have one.
Yeah, I mean, public
Otherwise,
defenders got-
I'd be in trouble being
I
up
mean,
here.
public defenders got law degrees too, right? Yeah. It's all good.
Okay, so innocent person or
I
guilty
both, like I
person?
said, both. It all depends what the situation is.
Okay.
There's a couple tangibles there, whether you can just say yes or no. Really.
Sure, number one, what do you think? All right. If you are faced with 5-to-1 odds, can you be the only person left standing? If everybody else on the jury has ruled, yep, guilty, but you strongly believe that my client is innocent, would you be able to stand up to the other 5?
I think that's part of why the jury system is set up the way it is that if I have a different opinion and someone in the court finds that upsetting, I'm gonna go back to my own life and do my thing and it's gonna be okay. You know? I'm gonna be up here and try to be as neutral and logical as I can, and I'm gonna stand behind it.
So at the end of the day, something that you make a decision based on your own interpretation of whether you felt that crime that is proven beyond reasonable doubt all elements. You're being swayed by other people that's not your representation of life.
Even if it's like 4:30, everybody's hungry, everybody's ready to go, and you're the holdout, still gonna be okay with that? Okay, what about you? Number three?
Yeah.
Yeah, okay, number two? Yeah. Okay, and number one? Yeah, okay. If you were sitting at the defense table today, and you've been accused of crime, would you want yourself as a juror on this jury?
Yeah, but I feel like that's a conflict of interest. Like, that's like a hard question to answer. So
Well, it's kind of impossible, right?
Right,
Like-
but so like, I mean,
Physically
yes, I
speaking.
think I would want myself, like a reflection of myself up there, represented. That's kind of an honest question.
Well, I think I am targeting more so to the effect of, are you going to be able to uphold all of the laws that you've been instructed to uphold, right? Are you going to be able to be fair and impartial? Yes, okay.
And that's what I'm doing.
Excellent. What about you?
Certainly. I think that it's back to your earlier point, right? It's central to our civic duty, the idea that we owe it to everyone in this room, right? Make sure the state proves that you're guilty before they put you in jail.
Gotcha.
I agree.
And you? You're number three?
Yeah.
You're number two? And you're number one? All right, last question. Can you promise to be fair and impartial and follow the law?
Yes.
Yes. Thank you so much for your time.
Mr. Martina, any challenges for cause?
No challenges for cause, Ron.
Any challenges for cause?
No, Your Honor.
Any preemptory, Mr. Martina?
Yes, the people would think and excuse juror number 3.
Juror number 3, you may be excused. Thank you.
Who?
You, juror number 3, you may be
I'm
excused.
sorry, I can't hear very good.
No, that's no problem. There's a lot of fans, so it drowns out the
Pretty hot.
sound.
I'm sweating pretty bad. I lost 135 pounds, but I'm still hot.
That's okay.
I'm halfway crazy. I went to pack a lunch. I'm
We
almost
don't
there.
we don't have any air in here, so you're free to go. Thank you for your service today.
Do I still get paid? Yes.
Yes, that you're following him. Any other challenges for preemptory for you at this time?
Not at this time, Your Honor.
As to this panel, you're satisfied with the others?
I am satisfied with the other 6.
Thank you. Any preemptory?
The defense would like to thank and excuse juror number 7.
Juror number 7, thank you. You may be excused. I'm going to replace juror number 3 with Terry Huff. Is Terry Huff here?
Yeah.
And we'll replace juror number 7 with Zoe Barber. that was all you wanted for peremptory, correct? Okay, you can proceed with arguing the new jurors.
Okay, welcome, New Juror 3, New Juror 7. Sorry if I'm rushing a little bit. Everyone who's not picked is gonna have to go over to Judge Buchanan, who's also picking the jury today. So basically, Jurors 3 and 7, you were both paying attention, right? Did you understand when I said that there is no right to face your accuser in the Constitution? Juror 3, did you understand that? When I said that the Constitution does not give defendants a right to face their accuser, do you understand that?
Don't sound right, but sure, yeah. Understand what you're saying.
You understand what I mean, that they have a right to confront the witnesses against them? Okay. Juror number 7, did you understand that? And do you understand that the case against Jalen Davis is being brought by the state of Michigan, not by an individual person? Juror 3, do you understand that? Juror number 7, do you have any experience with domestic violence? Do you have any friends or family with experience with domestic violence? No. Sorry, we need
Sorry,
to
no, sorry.
Okay, yeah, I need to
Sorry.
use that
I
outside
got
voice
you.
in here,
Okay.
yeah, okay. Can you think of any reasons why someone who was assaulted by a significant other wouldn't come to court?
My initial thought when I was over there was just fear of just confronting them.
Just being scared of being in the same room?
Yeah. Yeah.
Now, juror number 3, do you have any experience with domestic violence? Not personally, but do you know people who have had experience?
No, not, they've been arrested, prosecuted for it. No. It's more like having arguments.
Okay, you've known people who've been arrested in that context?
No, I didn't.
Okay, I think I understand. Can you think of any reasons why someone who was assaulted by a significant other would then not come to court?
Change their mind. Possibly they're not alive. Or shot.
Okay. Change their mind about like wanting the case.
Right.
No longer alive. I'll let you know that Sapphire Pond is still alive. So that's not, you know, we're not supposed to go into the facts of the case, but I just will put that out there. She's still alive.
Okay.
And maybe they're just shot. Okay. Now, do you understand that I don't have any duty to produce a victim to prove my case?
Why don't you?
Well, because it is the state of Michigan that has charged the defendant with breaking the law. And we can go about proving that he broke a law with other witnesses, right? So we don't need to have, because ultimately a crime victim is a witness. So we have no requirement to produce the crime victim to testify. Does that make any sense to you?
Yeah.
I think the example, I'm gonna play with fire and compare it to murder, right? If someone is murdered and the victim's not gonna testify, right? Then we can still prove that someone was murdered, even though the victim never came to court as a ghost and said, this is the person who murdered him. Does that make sense to you? Juror 7, do you understand that I don't have an obligation to produce the victim today? Do you have any questions about that? Are you willing to find Jalen Davis guilty, even if Sapphire Pond never walked in this room?
If the evidence provides that, you know, that did happen, then.
So there's other evidence that persuades you, even if you never hear from Sapphire Pond?
Yeah, if it's beyond a reasonable doubt.
Do you think that you would find yourself in the bathroom saying, well, if he was guilty, she would come to court?
No.
Juror number 3, do you think you could see yourself in the bathroom saying, well, if she was guilty, if he was guilty, she would come to court? No.
He can be guilty with facts.
Do you feel okay? Do you feel okay about me trying to prove my case without her ever coming to court? Fine.
Yeah.
Now, juror number 3, what's the difference between self-defense and retaliation?
Self-defense.
trying to fend off somebody that's attacking me. Retaliation. If somebody does something to you, turn around and do something to them.
And do you understand that retaliation is not a defense to an assault charge?
Right.
Juror number 7, what's the difference between self-defense and retaliation?
So for me, retaliation is more malicious intent, and then self-defense, I'll say if you're being hurt and you defend yourself.
Now, juror number 7, do you understand that my burden today is to prove the elements, not the exact details of what
Yes.
happened? Would you feel okay with reaching a verdict of guilty without knowing exactly what happened?
Yes.
Juror number 3, do you understand that my burden is the elements, not the details? Would you feel okay about finding Jalen Davis guilty without knowing exactly what happened?
It all depends on facts that you present.
So just, you can't answer that now, you need to know.
I need to
You
know
need to
more
see it
about
first.
what's going on.
Thank you both. I'll turn it over to the defense.
Welcome. All right, you heard my questions. Are there any that you would personally like to respond to? Share your thoughts. I'll start with the fun one then. Okay. What would you say if I told you I don't have to do anything? I can sit over there and I can play piano or go fish. Would you be able to find my client not guilty?
Depends on facts of the case.
Yeah.
And is he innocent or guilty right now?
Innocent.
That's where we're listening. What are some reasons that a complainant might not show up to testify in trial?
They feel intimidated. Just want to divorce themselves from the situation. It's the state bringing the case and that person.
Yeah, I was gonna say basically the same thing with that. It's just like me, I was like I was. Oh, I'm glad.
What about maybe them feeling a little bit insecure about things that they said? Could they potentially be nervous about cross-examination?
Sure.
What might be some reasons that my client can take the stand today?
Incriminating stuff.
Yeah.
Are there other reasons?
Could be innocent.
Very good. Okay. What about like social anxiety or autism spectrum disorder?
Be possibility.
Possible? Okay. What's more troubling to you? An innocent person being found guilty? Guilty person being acquitted?
It's innocent.
Now, if you're the last person holding out, okay, and you feel like Mr. Davis is not guilty, but everybody else in the jury feels like he is, and you can be able to stand your ground?
Yeah. He's innocent.
Even if it's 4:30, and you're starving, you're ready to go home, go eat dinner.
It should be.
If you were sitting at the defense table, would you want someone like you on the jury?
Yeah.
All right, and then lastly, can you promise to follow the law, and be fair and impartial?
Yes.
Yes. Thank you.
Any challenges for cause?
No challenges for trial, Your Honor.
None for the defense either, Your Honor.
Any free and jury?
No, Your Honor.
Yes, Your Honor. The defense would like to thank and excuse juror number 7.
Thank you, juror number 7, you may be excused. Replacing juror number 7 is Daryl Smith. You can proceed, Mr. Marshall.
Okay. Welcome to jury box, jury number 7. Did you understand what I was saying about how there is no right to face your accuser, but there is a right to confront your case?
Yes,
Did that make sense to you?
yes,
Do you have any questions about that?
no,
You understand that this case is being brought by the state of Michigan, not by an individual person?
yes,
And do you have any questions about that?
no,
Do you have any experience with domestic violence?
no,
Do you have any friends or family who've had experience with domestic violence?
not that I can. All.
Okay. Seemed a little hesitant there.
I mean, you always hear rumors and things like that, but you don't necessarily know the facts, so.
Okay, so you've heard rumors floating around, but nothing that you really heard firsthand. Can you think of any reasons why someone who was assaulted by a significant other might not come to court?
Yes.
What are some reasons?
Fear, fear stupidity,
Fear of what?
retaliation, change of heart. You not feel comfortable. Cross-examination, all of those.
And if Sapphire Font does not come to court today, does not testify, would that make you believe that Jalen Davis must be innocent? Now, what is the difference between self-defense and retaliation?
Self-defense is if somebody is attacking you, that you have the right to defend yourself. Retaliation is the attack has subsided or gone away and you go back and do something.
And you understand that retaliation is not allowed.
Correct.
Now, do you understand that my burden of proof is to prove the elements, not the details?
Yes.
How would you feel about reaching a verdict of guilty if you don't know exactly what happened?
If the proof of the case has been guilty, then that's what it is.
All the questions I have. Thank you.
Welcome, juror number 7. You just answered for Mr. Marchina, if a person doesn't come, might be the reasons, right? So if they initiate police contact, and they file this claim, but then they don't show up in the process or during prosecution, and you listed some reasons. What if I modified the facts to that person initiating contact? What if they hit the accused? What might be some reasons then that they not come to court?
Change their mind. once the police are called, state wants to prosecute, the person can change their mind all they want. But may or may not change the course of the state choosing to prosecute.
Might they have pulled out of prosecution because they were afraid of their own prosecution, of being prosecuted themselves?
Oh, I don't know. Honestly, I guess. The cross-examination. That's, I don't know if that's the thing, if that's possible. That they were to come forward and say something, they could get themselves in.
You mean incriminating statements like I hit so-and-so first?
Or lying under oath could also come with charges. If someone lied under oath.
Okay.
How do you feel about the fact that the defense doesn't have to do anything?
Seems weird, you don't do anything.
Yeah. Even if the law tells you that we don't have to?
Never heard that before.
Wish you did, I read it.
So I was
The
trying to set you up.
defendant doesn't have to do anything.
I'm, for now, I'm not familiar with that.
All right. Well, how would you feel about my client not taking the stand today? Would you be able to still find him not guilty even if he doesn't take the stand in defense of himself?
Yes.
If you were facing 5 to 1 odds and you're the only person in the room who believes that Mr. Davis is not guilty, could you hold your ground against the other 5?
Absolutely.
And if you were sitting at the defense table, would you want you on your jury?
Probably.
Explain that to me. Why is that not 100% certain?
100% certain. You don't know all that.
Can you promise to follow the law and be fair and impartial?
Long as we not seen it.
Do you remember?
And I remember.
Thank you.
Can we challenge the cause?
No, Your Honor.
None for defense. Your Honor.
Anything in jury?
No, Your Honor.
None from defense either, Your Honor.
Ladies and gentlemen, we have a jury. The remaining of you will be excused so that you can go around the corner to Judge Buchanan. Sarah, it's good to see you, by the way. We used to go to the same church. And so thank you for being here, being attentive, and best wishes to you around the corner. You all may be excused. All right. Remaining of you may be seated. When he returns, he's going to issue you a sticker that does denote you as a juror. I'm going to release you also to have a lunch break and be back here at 2 o'clock to go over preliminary instructions and then opening statements, and then we'll proceed with the testimony. You are not to speak to any of the attorneys. You're not to speak to any of the witnesses, nor the court staff. And because you don't even know who the witnesses are, you have to be careful of who you speak to, even if it's not about the case, because it could give the appearance of something that's improper. And so be careful when you're in the hallways, or if you're in the lobby or the elevators, or even in the restroom. There is a restroom in the jury room, which you all will have exclusive access to. But some of you may feel more comfortable using the restroom downstairs. There may be a witness or someone in there, so be careful
If anyone tries to talk about the case or what you believe may be the case because you know nothing about it, in your presence, please tell them to stop, let them know you're a juror, and then you will notify my court staff immediately if they do not follow your directive to stop speaking about the case. So again, I'm gonna let you leave. You'll be back here no later than 2 o'clock so that we can start promptly at 2 o'clock. I am just waiting for the court officer to return, and then he will release you with your sticker and give you access to the jury room if any of you all want to stick around. To begin. If they were ready to go. And they were, because that's where they sent somebody down here.
Can I ask you a question?
Yes.
Are we allowed to let family or anyone like might want to update, let them know that we've been selected?
Absolutely.
They don't give
Oh,
out
absolutely.
details.
Yeah, that you can use your phones. It's just not at deliberation. You're not allowed to. We haven't gotten that.
Your Honor, can I make a disclosure as well, Your Honor?
Yes.
I don't, it will not affect my ability to be an impartial juror, but I wasn't asked any questions about what my profession is. And I think everybody should be clear that I'm the executive director of a labor union that's headquartered here in Lansing that represents police officers.
That was there for them to ask. They didn't ask. They don't get to use it now. Yeah, we get, and we do get your.
Okay, I
all
just
of
wanted to be
that,
sure.
yeah.
I thought there would be a
Yep,
moment where I'd have a chance to
if
share
they
that.
don't, if that's not an interest of them, then they don't have to use that as a qualifying factor for their jury.
Thank you.
Thank you, but thank you for being upfront. We can excuse the jury for their break.
Okay. All rise for jury.
What's the matter?
DJ.
No, you gotta excuse them.
Oh, okay, Kristen. All right.
Yeah.
All right.
Choose yourself. What did I do? Did I do something? Oh. No, I did. Yeah.
This is the matter. Matter of the state of Michigan versus Caria Lazan and 25-01697.
Ross Marsh, speak up for the people.
Assistant Public Defender Joseph Hardy of the package design, who is seated to my right.
Okay, Ms. Lazan was scheduled this sentencing today. I do have a pre-sentence report that was prepared back on the 16th. You got a copy of that, counsel?
Yes, Your Honor.
Yes.
We need to make corrections, updates, resolutions.
None from the people.
None from the defense, Your Honor.
You can allocate.
Your Honor, Ms. Lazan, as someone that's currently collecting SSD, she's someone that is currently seeing a psychiatrist. As you may recall from the plea, her mental state was definitely one of the underlying issues that caused discharge to be issued. I'd like to note that according to the report that she was very honest and forthcoming on everything review, that she does have several documented mental illnesses, including bipolar disorder, schizophrenia. She's currently on medication. I've seen a psychiatrist since May of this year, so around 2 months. At this point, I would argue against probation for fines and costs, simply because I believe that she is currently seeing mental health counseling. I believe that with this being the only thing on her record, that this is not something that is typical of her behavior. So we would just ask that she be allowed fines and costs, and we would have no objection if there's any requirement of proof of mental health counseling to be provided. As I said, she is currently getting mental health care.
Do you have proof of that with you today?
I do not, Your Honor, but what was represented to me is that she was seeing psychiatrist at was it Pure Psychiatry with Dr. Morgan.
How long have you been seeing him?
It's a female.
For her?
Since last May.
Since last May. Well, the incident occurred, I think, last April.
No, that's what I'm saying, after the incident.
Yeah,
happened.
that's what I'm saying too.
Yeah, right after the incident happened, they took me to Kalamazoo Behavioral Mental Institute. I stayed there for 20-some days and got on my regular medication, and then I started seeing her after I went.
So you've been seeing her consistently since then?
Yes.
I agree. She doesn't even remember the incident. I believe she pled no contest because of her lack of memory of the incident. She was in the psych wing when the incident occurred. I wouldn't put her on probation either for that purpose. She needs to get on her proper medication and treatment. She appears to have done that. She's never missed a court date. She's never had any violations of any kind. She has nothing else on her prior criminal history. And she has credit 1 day of jail.
That's my understanding as well, Your Honor.
Credit her 1 day for jail. There's a $75 crime victim rights fee that will be assessed as a $50 state minimum cost. We don't see restitution. We won't order any discretionary fines and costs at this time. When is she gonna pay the $125?
Yes, we need to be able to pay the first, as mentioned, she's on a fixed income, so I believe the first would be the best time.
Okay, I'll note that she'll make payment within 30 days. Do you have any questions for the court today, ma'am?
No.
Any additional matters for the record?
None for the people.
No, Your Honor.
You're all set, ma'am. Thank you. And thank you for your patience today.
Thank you.
We also have a Miguel Julian here.
I couldn't hear you.
We also have a Miguel Julian here as well. He had said that he was out in the hallway at the time where he said that he was sitting. Can't say that I had walked down that far, but when I had called.
Where was he sitting? What time did you get here? You got here at 9:40 and sat where? Excuse me? In the middle of what? Why did you sit down there? Who did you check in with? How are we supposed to know you're here if you come in and you go and sit in front of the clerk's office? Excuse me? No, you didn't come and check in when you come to court. You came to court. You didn't come to sit at the clerk's office. I asked your attorney, had he seen you? He said no, and he had not seen you. This matter needs to be reset. When you come into court, you check in. I'm assuming there's no offer from him.
Not
As of now, no office, correct.
So you want a final pretrial?
Yeah, that was gonna be our intention.
I don't know. I don't think I signed eventually. I don't think so. So did I give you the final at all? Oh.
August 11th at 8 a.m.
August 11th, 8 a.m. in person for a final pretrial. When you come in, you're supposed to check in with this guy right here, or whoever the judge is that you're here to see, okay? You can't just sit in the hallway, down the hall, and think that we're catcalling, yelling your name down the hallway, okay? There's not been an offer at this time, so we're gonna set it for final pretrial, okay? And then we'll also set it for jury trial. September 29th at 8. September 29th at 8 a.m. We'll get you a notice in just a moment, okay? Thank you. I think all the, well, where's the defendant? Where's the defendant?
Oh, wow.
Okay, well, before you do that, make sure all of them enter and close the door.
Is there notes on that thing?
There were just a quick question, yeah.
Okay, thank you for returning back from your lunch. We have some instructions before we begin opening statements. Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try this case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. If the jurors could please rise. Okay, do each of you solemnly swear or affirm in this action now before the court that you will justly decide the question submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced in accordance with the instructions of the court? If you do so, say I do.
I do.
Thank you. You can have a seat. No, was it attached to that one? That's all. Okay, you will have a written copy of my instructions I'm going to read to you. However, you will not receive it until the trial is completed. At the close of the trial, I will provide you a final copy of my instructions for your use during deliberations. Now I will explain some of the legal principles you will need to know and the procedure we will follow for trial. The defendant is charged with a crime of domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant either assaulted or assaulted and battered a Sapphire font. A battery is a forceful, violent, or offensive touching of a person or something closely connected to him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Sapphire font's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Sapphire font reasonably fear an immediate battery. An assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit a battery or must have appeared to have the ability or must have thought he had the ability. Second, the people would need to prove that at the time Sapphire font was either one of these following: either the defendant's spouse, the defendant's former spouse, had a child in common with the defendant, was a resident or former resident of the same household, or was a person with whom the defendant had or previously had a dating relationship. And a dating relationship means frequent, intimate association, primarily categorized, that is. Let me slow down. Characterized by the expectation of affectional involvement. It does not include a causal relationship or an ordinary fraternization between two individuals in a business or social context. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about October 30th, 2025 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime, excuse me, is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt,
then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that. It is a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes his, or she may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Excuse me. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the lawyers will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about the evidence and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender identity, or sexual orientation or religion, or age or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness is testifying? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? When it is time for you to decide the case, you are allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence, only the answers are evidence. You should not think that something is true just because one of the lawyers asks a question that assumes or suggests that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my own opinion about the evidence. If I ask questions, my only reason would be to ask about things that may have not been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and then pass it to my court staff, who will give it to me. Do not show your question to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the lawyer or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all of the other jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop, explain that you are a juror and you are not allowed to discuss the case. If they continue, leave and report the incident to my court staff as soon as you return to the court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you must consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The instructions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that the jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. Again, for example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case. including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with anyone, you must not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. As you can see, we have chosen a juror of 7. After you have heard all the evidence and my instructions, we will draw names to decide which one of you will be dismissed to form a jury of 6. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about the case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives than yours. Give me just a moment. Taylor Zim. Just joined my meeting room named Taylor Zim. Need to unmute, ma'am? Okay, what's your name?
Taylor Simmons.
Do you have a case number?
Think it's like 26-04156-LT.
Definitely not today.
It's not it.
No, you said LT, so that's landlord tenant, and we don't do landlord tenant on Tuesday, so I'm gonna find out when your court date is. Tomorrow at 2:45. Tomorrow at 2:45.
Oh. Okay, all right, thank you.
You're welcome. opening statement.
Okay, thank you all so much for bearing with us throughout this day so far. As you can tell, there's a lot going on in this court, a lot of hold up, but we're addressing other things, a lot of waiting around. It's hot, you'd probably rather be other places, so really, thank you so much for being here. This case ultimately is about a relationship. It's about a toxic relationship and abusive relationships. Specifically, today, we're here to talk about October 30th of 2025. We're going to talk about Jalen Davis. We're going to talk about Sapphire Fawn, how the two of them they used to date, and how on October 30th they got into an argument that got pretty heated. Unfortunately, I'm not going to be able to give you information about what they were arguing about, but I will be able to tell you that at a certain point in time, Mr. Davis decided to pull out his phone and start recording Sapphire, pointing the camera at him. Sapphire responded to this by trying to push the phone away. And then Mr. Davis responded to this by slapping her in the face repeatedly. And at some point in time, Mr. Davis was also holding a gun. And Sapphire called 911 to report being assaulted, to report that he had a gun. At that point, Mr. Davis left. And we're going to establish that later, Mr. Davis comes back and he still has a gun. And they're arguing while he is continuing to hold a gun. And other people are calling 911 again. And then again, he runs. Then you're going to hear that he comes back again and begins trying to break into Sapphire's house. At this point, Sapphire calls 911 again. A neighbor calls 911. And before the police get there, you guessed it, he's guilty. And we're going to prove this to you beyond a reasonable doubt, and it's going to leave you convinced that the defendant is guilty of domestic violence. Now, the witnesses you're going to hear from today, first you're going to hear from Eugene Fraser, maintenance man in the area where they live, who knows Sapphire, who at least knows of Jalen Davis. And he is going to talk to you about his interactions with them, about the concerns he has with Sapphire. He's going to tell you about how he has called 911 to them previously, how he called 911 this day because he saw Jalen Davis out at Sapphire's house with what seemed to be done. And you're going to hear the 911 call in place that. You're going to hear from Lydia Chapello, who was one of the police officers who responded that night. She is going to tell you about taking a statement from Sapphire. We're not going to tell you what Sapphire said to Ms. Chapello because that is something I will bog you down with the rules of evidence. It's not something that we can give you today. We're going to hear that she took a statement. She took a statement from Mr. Fraser. And you're going to see some pictures that she took of Sapphire. Now, with these pictures, I'm going to draw your attention to is not any injuries, not swelling. What I'm going to draw your attention to is tears. Her eyes are filled with tears. There's a clear tear mark from tear running down her face because that was someone who's telling the truth. That is someone who called 911 in fear. And you're going to hear from Detective Sarah Wilson from the Lansing Police Department. And at that point, that's going to be the bulk of our case. You are from her going to, we plan to admit something called CAD minutes. I won't bog you down with what that is, but basically it's this big packet summarizing all of these 911 calls. Okay, that's not something I'll hand to you during the trial, but will be available for you in the jury room if you decide you want to look at it. And then from there, that's going to connect us to several more 911 calls. And my expectation is that with Sarah Wilson sitting here, you are going to hear another 4 911 calls, 2 of which placed by Sapphire Fawn, 2 of which placed by someone who identifies himself as Ray. You're not going to hear from Ray. There's not even, I can't establish for you that Ray is his actual name. I don't know anything about Ray. You're going to hear 2 911 calls that he placed, an extreme concern for Sapphire's safety as a result of the action of James. And all of that, when put together, testimony from these witnesses, the 911 calls, the photographs, the CAD report, all of that put together will prove beyond a reasonable doubt that Jalen Davis is guilty of domestic violence. And because of that, at the end of the trial, I'm going to come back here before you and I'm going to ask you to find me. Thank you.
Ms. Stroud.
Members of the jury, the evidence in this case will not show that my client committed a crime. Rather, it will show a snapshot of a highly emotional, fleeting moment between two people that has been blown entirely out of proportion. Mr. Martino is right. This does involve a toxic relationship between two people who didn't get along that night. Okay, that's very clear in the facts of this case. What is not clear is who did what and what actually happened. I know that Mr. Martino has mentioned to you that the details don't matter, but actually details very much matter. And investigations are designed to flesh out details and to determine what actually happened. Okay? Again, the defense's burden today is not to prove anything. Okay? We do not have to do that. We simply have to show up. But I would ask you today to pay attention. Okay? Use your best faculties, use your common sense, use your experience, and draw your conclusions based on what you actually see, facts. Okay? Not hunches, not opinions, but actual facts. I want you to think long and hard about what you would expect during an investigation. What steps should detectives be taking? Okay. Should they be interviewing all of the witnesses? Should they be making sure that there are at least one eyewitness to this? Should there be physical evidence available? Okay. Should there be indicators in the vicinity of where this is supposed to have happened that would tend to indicate that it actually happened? Okay, signs of distress, signs of a struggle. Okay, we touched very quickly on an injury. There isn't. Okay, we should be looking for things that independently suggest that a crime actually occurred. Not hunches, not opinions, facts. At the end of this trial, after you see the lack of physical evidence, the inconsistencies in statements, and the absence of the complaining witness, the prosecution will have failed to meet its burden. And when that happens, I will ask you to return a verdict of not guilty. Thank you.
Call your first witness.
You can call Eugene Frazier. Come right up here and turn towards the judge.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
You can have a seat there, sir. Okay, that microphone that's in front of you is so that the court recorder can pick up the sound of this recording system. It will not amplify your voice. We do have several fans going on in this courtroom to try to keep it remotely cool. So it does drown out the sound, so if you can keep your voice loud so that we can all hear your responses. If there's an objection from either side, you'll stop speaking. That objection requires me to make a ruling, and I will advise you then if you're able to give the answer or not. All of your responses to yes or no questions must be verbal. They can't be head nods, head shakes, or mm-hms and ahs, because that cannot be articulated into the record accurately, okay?
Yes, ma'am.
State your first and your last name and then spell both.
Eugene Allen Frazier Jr., Eugene Fraser.
Now, Mr. Frazier, what do you do for that?
I'm work for the Lansing Housing Commission on maintenance man.
And your work, did it take you to properties on Grovenberg?
Yeah, and I live in Grovenberg.
Okay. And in living and working in Grovenberg, have you come to know someone named Sapphire Font?
Yes.
And how do you know Sapphire?
She was one of my tenants, my neighbor.
Where does she live? Where did she live relative to you?
Be right next to me.
So what kind of, I guess, structure?
It's a duplex. There was a driveway between our duplexes.
So she lived in the duplex next to your duplex?
Yes,
And your time living there and living next to Sapphire, did you come to encounter someone named Jalen Davis?
yes,
And do you see Jalen Davis in the courtroom right now?
yes.
Could you please tell me where he's sitting and describe his clothing?
He's wearing a suit, blue suit, a blue and white shirt.
And for the record, the witness was looking towards the defense table, and for the record reflect he has identified the defendant.
No objection.
Participation noted.
Now, how have you come to cross paths with Jalen Davis?
Through Sapphire, through her coming to my door and waking me up at night because he's been putting his hands on her, trying to break into the house.
And did you have knowledge of what sort of relationship Sapphire had with Jalen Davis?
Yeah.
What was Sapphire's relationship to Jalen?
Through what Sapphire was saying, they were boyfriend and girlfriend.
Okay. And did you have occasion to see Jalen Davis at Sapphire's home?
Oh, yeah.
Was he there pretty regularly?
Yes.
Now, did you feel any responsibility to, I guess, look out for Sapphire?
Absolutely.
Why did you feel that kind of responsibility towards her?
Because she was a female and there were 2 young children in the house.
Now, we're going to talk about October 30th, of 2025, okay?
Okay.
Do you remember that day?
Yeah.
Did there come a time that day when you felt the need to call 911?
Yeah.
And what was the reason for your decision to call 911?
Sapphire woke me up, beating on my door, saying that Jalen had and his buddy had trapped her in the house and proceeded to beat her.
And did there eventually come a time when you saw Jalen outside of her house that day?
Yes.
And when you saw her outside of the house, did you call 911?
Yes.
And if you were to hear some audio from 911 call, would you recognize it?
Yes.
Showing the fence table, that is the mark as this pros exhibit 3. All right, first witness. Play a little bit.
That's me.
And is that the call that was placed on October 30th?
Yes.
Your Honor, this time the people move to admit pros exhibit 3.
Any objection? No. Freeze in a minute.
Will now publish exhibit 3.
What is the location of the emergency?
Hi, it's 6203 Grovenberg. You guys just had a bunch of police out here looking for the guy. He's back in that girl's house right now.
Okay, what is your name?
Eugene. I'm her neighbor. I can hear them two in there yelling. He's back in that house.
What's your phone number, Eugene?
517-703-3067. He's out front on the front porch. Right now.
Do you see any weapons?
He's got something in his hand, but I don't know what it is.
Okay. I'm gonna add this to the call. We already have officers on their way back, okay?
Right, he's on that porch.
Okay, I let them know. All right, bye.
Now, did you eventually come to have a better look at what Jalen had in his hand? Now, at the time you called 911, had police already been around that night? Now, Jalen and You said the woman that you referred to the 911 call was that Sapphire?
Yes.
The two of them arguing in the house, why did that cause you to feel the need to call 911?
That was the second time that night that happened. The cops had already been there once.
At
And I
that
think
point,
she called him.
at that point, were you concerned for anyone's safety?
Absolutely.
Whose safety were you concerned for?
Sapphire and the kids.
Did you have reason to believe that Jalen Davis was in danger from Sapphire?
Absolutely.
Absolutely. I'm sorry. Let me rephrase the question. Did you have any reason to believe that Sapphire was somehow threatening or harming Jalen?
Oh, no.
Now, have you had previous incidences in which Sapphire has come to you for help?
Yes.
Is it something that had occurred pretty regularly in the course of her relationship with Jalen?
Yes.
Sorry, we need to not speak at the same time.
Okay, I'm
because-
sorry.
No, because later down the road, Miss Nash might have to type a transcript, and it's hard when people talk at the same time. Now, that night, did there come a time when you eventually brought Sapphire somewhere else?
Into my home
And why did you bring her into your home?
for safety.
And did you also bring her children into your home? Do you remember?
That I don't remember. I don't. But I to be honest, I don't even know that night if the kids were there and what the kids were using there.
But you do remember that night you brought Sapphire into your home. Now, what is your address in this Groveland?
6209.
And do you know the address of the place where Sapphire was living?
6201 or 3.
6203. And this location, is it in the city of Lansing?
Yes.
Is it in Ingham County?
Yes.
Now, did you also have occasion earlier today to listen to some snippets from other 911 calls?
Yes.
And do you recall hearing 2 calls with a female voice?
Yes.
And did you recognize the voice in those 2 calls?
Yes.
Whose voice was that?
Sapphire.
That's all the questions I have. Thank you.
Cross-examination.
Mr. Frazier,
Hi, ma'am.
you didn't see Mr. Davis strike Miss Fant on October 30th of 2025.
No, ma'am.
In fact, you weren't even in her home when this alleged incident occurred, were you?
No, ma'am.
So everything you know about that day flowed through Miss Fant. Isn't that
Yes, ma'am.
correct? However, you're involved in this matter because you gave police statements about Mr. Davis returning to Miss Fant's residence that evening, right? And you indicated to police when they arrived for a second time to the scene that you saw Mr. Davis
Yes,
on the
ma'am.
front porch. Where were you when you saw him?
And then I think I had my screen door open, looking towards her house.
Okay. So you would have been on the same side of the street as her,
Yes, ma'am.
right? And then if her door's here, you would have been on this side of that door?
Well, my house is here. She would have been to the left, of me.
Okay,
To the right of me. I'm sorry.
to the right, that's what I thought. Okay, perfect, thank you. How far would you say Miss Fant's porch is from yours?
10 feet, 12 feet, maybe.
Okay, approximately what time was it, do you recall?
1, 2 o'clock, maybe in the morning.
Okay, so it would have been dark outside.
Dark outside.
Okay. Now, you say you saw Mr. Davis with something in his hand,
Yes, ma'am.
right, in his left hand.
Sorry, I couldn't hear your response.
Said I didn't say what hand it was in.
Okay.
I couldn't see it either way.
Okay, did any officers come to your door and kind of position themselves in the position that you would have been in and kind of look from your door over to Miss Vance?
Not that I
Front porch?
recall.
Okay. So they didn't like try to remodel what had happened there. So you mentioned that Miss Vance is a tenant.
The company I work for, yeah.
Okay. And you mentioned having knowledge about other incidents,
Yes, ma'am.
but personal knowledge, as in like you those things, you observed them happen
I
yourself.
observed one thing happen, the physical abuse I didn't.
Okay, so not physically, no assault and battery. Okay. But you did witness her break his car window before, didn't you?
You object to relevance.
Well, Your Honor, the basis of our theory today is that there is a toxic relationship, as a two-way toxic relationship. It doesn't necessarily mean that an assault and battery occurred.
Okay, so your question about his observing her cause damage to the vehicle.
Having some volatile capabilities or having shown that act before, or
Are you saying that this is something that happened that day, or are you talking
No,
about
Your Honor.
previous day?
a previous time, different.
It's not relevant. You don't have to answer that question. Objection sustained.
You mentioned during the call to 911 that Mr. Davis was back inside the house.
Yes, ma'am.
But at another point during the call, you mentioned that he was trying to break into the front door.
I'm not wrong, I didn't.
No further questions.
Okay, now, just to clarify, your testimony is that you did not in this call say that
Not that I.
people are
that
gonna
he was
go
breaking
ahead,
in.
people are gonna go ahead and republish exhibit 3.
911, what is the location of the emergency?
Hi, it's 6203 Rosenberg. You guys just had a bunch of police out here looking for the guy. He's back at that girl's house right now.
Okay, what is your name?
Eugene. I'm her neighbor. I can hear them two in there yelling. He's back in that house.
What's your phone number, Eugene?
517-703-3067. He's out front on the front porch. Right now.
Do you see any weapons?
He's got something in his hand, but I don't know what it is.
Okay. I'm gonna add this to the call. We already have officers on their way back, okay?
Right, that my porch.
Okay, I let them know. All right, bye.
All right, now having heard that call, did you ever say that he was trying to? Now, the person that you saw on the porch, do you have any doubt about who it was?
No, the porch light was on.
Now, did you see Sapphire that night?
Yes.
What did she look like when you saw her that night?
Oh, she had hand marks around her neck. Her eyes looked black. Her mouth was bleeding. Her hair, it looked like it'd been pulled.
No further questions.
Any questions from the jury for this witness? You can write your question down, please. Very good. Our council, you can go. So funny that these questions are connected to each other. I don't know if this is what this that you intend to address now. Okay, and you may or may not be able to answer this, but to the extent that you can, Mr. Frazier, do you know if Mr. Davis lived in the unit or the apartment with this man?
Wasn't on the lease, but I know he was there enough to say he lived there.
Okay, do you know how long? Yeah, you believe he lived there?
I think she was there 3 months and he was there 98% of the time.
Okay, so she had not lived there that long herself.
No.
Okay, got it. Very good question, and both questions were connected to each other, actually, so everyone's on the same thought process. Any more questions? You can write your question down. Council. Yep, you can grab the other question, or one of you all can grab one. You can get it. You can get it. Cause you didn't try to touch your hands. They into the elements here. What wonderful questions. I mean, you all are really asking some really pointed questions that go directly to the elements of the charge. So one of the questions we have for you, Mr. Frazier, is if you know, were the children that you're discussing, do you know if those are Mr. Davis's children?
I don't know if they're or not, no.
Oh, okay. And then was Mr. Davis seen in a breezeway or mudroom? Or was this like, was there enclosed porch?
There's not an enclosed porch, it's open.
Okay.
Just a concrete pad that he was standing on.
Concrete slab. Okay. This is it's an apartment building or public?
It's a duplex.
A duplex, okay. And then I think that answers the question. If not, you can, whoever wrote that question can send a follow-up. Any more questions for this witness? May this witness be excused?
Yes.
Yes, Your Honor. Thank you very much, Mr. Frazier. You may be excused.
Thank you, ma'am.
You can call your next witness.
People will now call that yet to come up.
again. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can have a seat. Okay, you testified in court before? Okay, please state your first and last name as well, both.
First name is Lydia, Olydia. Last is Chaplow, Chapello.
Take your seat, counsel.
Officer Chapel, how are you employed?
I'm with the City of Lansing Police Department.
And what is your role with the City of Lansing Police Department?
I'm a uniform patrol officer. I respond to calls for service.
And how long have you been in this job?
2.5 years, sir.
And were you working in that capacity on October 30th, 2025?
Yes, sir.
And did you have occasion to respond to a call at 6203 Grovenberg?
Yes, sir.
And that location, is it in the City of Lansing?
It is.
And is it in Ingham County?
It is.
Now, what was the nature of this call that you were responding to?
It was for an assault, a domestic assault.
And did you come to have contact with someone named Sapphire Pond?
I did.
And did you take a statement from this Pond?
I did.
And what was, I guess, her demeanor like when you were taking this statement?
Extremely upset.
Was she crying or anything like that?
Yes.
And now the person who was the accused in this incident, was he present on scene?
He was not.
And were you given any information about what he looked like, where he might have gone?
I was.
So did Sapphire give you a description of what he looked like?
She gave me a name and then she gave me a description of who he was.
And did she give you information about where he might have gone?
I don't recall.
Now, this first time that you were there, did any other police come?
Yes.
And did the other officers make any efforts to try and find the person she described?
Yes.
And what did the other officers do?
We had a canine officer respond to do a track for our accused.
And to your knowledge, was this track successful?
It was.
Now, if you were to see photographs of Sapphire from that night, would you recognize them?
Yes.
All right, showing defense table people's pros exhibits 6, 7, and 8. Your Honor, may I approach the witness?
Please.
Approaching with proposed exhibits 6, 7, and 8. Do you recognize those images?
Yes, I do.
Who is the person in those pictures?
That's Sapphire.
And those pictures, do they fairly and accurately depict how she looked that night?
Yes.
Your Honor, this time the people move to admit proposed exhibits 6, 7, and 8.
No objection, Your Honor.
People 6, 7, 8 are admitted without objection.
All right, people will go ahead and publish those on the monitor. All right, this is people 7. Now this appears to be her right profile, is that correct? You speak a little louder.
Yes.
Now over here where I'm zooming in, what does this appear to be sort of down the cheek?
Tears.
And moving on to, this is people's 8. Is this her left profile?
Yes, sir.
Now, moving in a little closer. Do its thing. Does that also appear to be tears under her eyes? Now pupils 6. And this is just a front-on picture of her face. A little blurry, but what it is, no less.
Yes, sir.
Now, did Sapphire describe having any sort of discomfort?
As far as,
Like, did she tell you that she was feeling any sort of pain or anything
Objection,
like
Your
that?
Honor, you're saying.
It's a statement of then existing physical condition, which is in this 1-803.
Your motion's over, I mean, your objection is overruled.
She described having any sort of pain at that point in time.
no, sir.
If you were to take a look at your police report, would that refresh your memory?
It would.
All right, showing defense table, police report. Your Honor, I have a question witness. All right, just take a look and then just let me know when you're finished looking. Did that refresh your memory?
It did.
Did Sapphire describe having any sort of pain or discomfort?
She did.
Where did she, what did she tell you about pain she was experiencing?
She said she was having head pain from being slapped several times.
Speak up, please.
Yes, ma'am. She said that she was having head pain from being slapped several times.
Okay, so she described having pain in her head.
Yes, sir.
Now, did you have occasion to respond to this address a second time?
Yes, sir.
What was the reason for the second response to this address?
The accused had shown back up on scene.
And at this point in time, did you take a statement from Eugene Fraser?
I did.
And was another canine track summoned?
It was.
And was this canine track successful with finding Mr. Davis?
It was not.
And then later, were you summoned there a third time?
I was.
And what was the reason for this third call to that address?
The accused was back and trying to pick in the front door of the residence.
You say that again a little louder.
Yep, the accused was back on scene for a third time and was trying to kick in the front door to the residence.
Okay. And then once again, this third time, did police have any success locating the accused?
No, sir.
I have no further questions. Thank you.
Chapelo. You weren't present to observe the dynamic between my client and Miss Bant prior to the 911 call, were you?
No, ma'am.
In fact, Miss Bant indicated to you that she placed that 911 call that night, didn't she?
Yes, sir.
And when you arrived, Miss Bant actively guided the narrative, didn't she?
Yes, ma'am.
You mentioned that she seemed upset when you arrived.
Yes.
Okay. And was she already crying at that time?
I don't recall, ma'am.
I didn't hear what you said.
I said I don't recall.
But when you arrived, Mr. Davis wasn't there, was he?
He was not.
So police weren't able to take a statement from him as to what happened, were they?
Correct.
There was another adult female present other than Miss Bant when you arrived, wasn't there?
I don't recall.
But you only took statements from Miss Bant that night, right? So no other person.
I took one from the witness.
An eyewitness? Someone
Eugene.
who had actually seen Mr. Davis strike Miss Bant?
No, ma'am.
You also didn't observe any videos of this alleged incident, did you?
Correct.
And there were no photographs of that incident either.
Correct.
Your report omits any objective description of physically observed injuries. In other words, you don't describe any impressions you may have had about injuries that you physically, visibly perceived from this man. Is that correct?
Correct.
Going back to these exhibits that we just viewed, can you kind of just indicate to me, describe to me where you would see any indication that Miss Fant was struck in her face?
A visible,
Yes.
there's no visible.
Okay, and so do you see any swelling, redness, split lip, bruising, black eye, knots?
Not in the photos.
Okay, any marks around her neck?
From the photographs, no, I can't see them.
Okay, did you view any when you responded that evening?
I don't recall, ma'am.
If I were to give you your report from that evening, would that help to refresh your recollection?
Sure.
All right, may I approach the witness?
Yes.
I think there's a section for injuries.
Oh,
Okay. I just want you to feel like you're free go.
yeah.
Thank you. So just revisiting my question, did you perceive any of those physical indicators of injury to Ms. Fant?
I saw no visible injuries.
How about the investigation of that scene? Was there any independent evidence that indicated a struggle had occurred?
I don't recall, ma'am.
Want me to give you, would that help to refresh your recollection?
I don't believe I wrote anything in there about that, ma'am.
Okay. So then no knocked over items or furniture or signs of blood anywhere, holes in the wall, ripped clothing?
I don't recall.
At any point during your interview with Ms. Fant, did she indicate to you who initiated the unwanted physical contact?
Objection calls for hearsay.
Being excited. That's wrong.
Your question was, did she ever indicate?
Who initiated unwanted physical contact?
Objection is overruled as cited under X. Answer.
She had stated that she had redirected the phone that he was holding in her face, recording her.
Were those her words?
For redirected, yes. That's what I wrote in my
She didn't
report.
say slap the phone out of his hand.
I don't recall, ma'am. That wasn't at my report.
If I would show you that report, would that help to refresh your recollection?
Yes, ma'am.
Let's do that. May I approach the witness, Your Honor?
Yes, you may.
Want me to refresh, like,
Yes,
question again?
ma'am.
Okay, that's fair. Do you recall Miss Fant saying that she slapped the phone or smacked the phone out?
I don't have any quotes in there of what she said from what I can see in the statement, but it says that she had hit the phone that was in his hand.
Gotcha,
In his
thank you.
hand. Yep.
And smacking an object that is in someone else's hand without their consent is a crime, isn't it?
Objection calls for legal conclusion.
She has to charge these crimes. She arrests people on a regular basis.
The police don't charge crimes.
Well, they do arrest people for them. an investigator.
You're questioning this, whether or not it's a crime?
Yes.
I think you're trying to get at whether or not it's could be considered assault. Maybe you want to redirect the question. Rephrase your question.
Is smacking an object out of someone's hand considered an assault and battery?
Depending on the circumstances of the situation and the facts of the incident, it could be.
Ordinarily, when a witness indicates to you that they've broken the law, do you just let them escape accountability?
Objection to relevance, lack of foundation.
Ordinarily, you want to know ordinarily if she lets people escape accountability?
Yes, when they make statements to the police that are incriminating in nature, does she routinely allow them to not be arrested?
Well, I think the foundational objection is valid at this point, so I'll
Okay.
grant the objection on the lack of foundation.
I'll redirect. Thanks, Ron. Is there a reason that you so readily sided with Ms. Gant that evening?
Well, my experience as a police officer, we have to have someone else on scene that would contradict her statements in order for there to be any validity in the other half of it. So she was the only one on scene, the only one that stayed on scene for the incident, so I took her statement, which is my job as a police officer.
Understood. Thank you.
Yeah.
Just visiting the accusation that Mr. Davis returned to the property that evening. He wasn't there when you got there, was he?
No, ma'am.
There's only one statement regarding him coming back to the property. Is that correct?
Correct.
And that's from Mr. Eugene Frazier.
Correct.
And you gathered that statement in person or via phone?
I don't recall, ma'am.
Do you recall whether or not you would have sort of reenacted the scene, so to say, or stood where his vantage point would have been to see if he would have actually been able to see Mr. Davis?
I don't recall.
All right, we'll try it again.
Use your recollection.
It's been a while.
Thank you. Thank you. I don't recall if I saw it from his vantage point from my report in my memory, but I do recall making a telephone call to Eugene to collect his statement.
Okay. But there's also nothing in your report that indicates you would have reenacted or looked from his vantage point.
Correct.
So we can't actually be confident that Mr. Davis hasn't actually returned, can we?
Objection. Calls for an answer that would lack personal knowledge.
Your question is that she can't be certain that
Mr. Davis had actually returned or had been there at all that evening.
I think she can answer that question. Objections overruled.
I was not personally there. I took witness statements that said that he was there.
And your confidence that he
As
was there,
far as
that he was actually there? You can't actually be confident that he was actually there.
I can answer that I did see him there. And I took a statement from the witness that said he was there. As far as whether or not he's there, it's based on the validity of the witness statement on my own personal beliefs.
One that you took via phone.
Yes, ma'am.
No further questions.
Redirect.
Okay, sorry to jump around a little bit. So you were asked if you looked through videos of this assault. You remember being asked that on class?
Yes, Sam. Oh, yes, sir. Sorry.
You're fine. Were you given any reason to believe that there had been a camera there recording this?
I don't recall.
Now you were asked if there were any, do you remember being asked if there were any pictures of the assault? Do you remember Ms. Traub asking you, were there any pictures of this happening?
Any videos or pictures of assault? Yes, I do recall.
Okay. In your experience as a police officer, is it common for someone who's being assaulted to take out their phone and start taking pictures of the assault that's happening?
No, that's not common.
Now, jumping forward to redirecting or smacking the phone, depending on the language choice. Did Sapphire tell you why she redirected or smacked the phone?
Because it was being held in her face.
And did she indicate who was holding it in her face?
Yeah, it would have been Jalen Davis, her ex-boyfriend.
And did she indicate whether or not she wanted him holding it in her face?
She did not.
Now,
Wait, she did not want it in her face, or she did not indicate?
oh, sorry.
Oh, my bad. She did not want the phone in her
Thank you.
face. Yes, ma'am.
Thank you, Judge. Why didn't you arrest Sapphire?
I didn't have any probable cause to arrest her. I had no victim on scene that said they were assaulted by her.
But she admitted to redirecting his phone. Isn't that an assault?
Depending on the circumstances, it could be, but you have to have a victim on scene to give a statement that said that they were assaulted.
So let me put it this way. When Sapphire described redirecting and or smacking the phone, at that point, did you believe you had probable cause to arrest her for assault?
No.
Now, in your training experience as a police officer, is it common practice for police officers to reenact crimes?
No.
I have no further questions. Thank you.
Any questions from the jury for this witness? This question. When were those photos taken? The photos that were presented to you? Do you know when they were taken?
Did not take the photographs.
Oh, you
It was
didn't take
another
them?
officer.
Okay, very good. Counsel, you can approach. Okay. Did you complete your report or your police report, the one that's refreshing your recollection, after your first visit to the residence or the second or third?
I don't recall.
Did you do multiple reports, you know?
There's multiple narratives.
Okay.
So,
Okay, and would you have done it immediately after your first, or does it vary?
depending on the rest of the calls for service for the night, so depending on how busy we are, it's either done immediately or it's done by the end of the night.
Good questions? Any other questions? I think there's two questions. Another one's coming. This literally. What officer took those photos? Do you know?
I don't want to give the wrong name, but I know it's in the report.
No worries. Okay. Counsel. Yeah. Any other questions?
One more.
One more question? This witness can answer that. See how she can answer. Yeah, I don't believe that this witness can answer that question either. She already testified that was not there on the scene when she was there. Any other question? Is another one coming? Run them down.
When he got picked up.
If you are able to answer, when Mr. Davis was later taken in on this particular case, do you know if there was any evidence to support Mr. Eugene Frazier's claim that there was a weapon, that he had a weapon?
I did not recall. Yeah, I was not involved in his.
I didn't think that she would be able to answer that, because I don't think she had any parts in him being brought into, and I don't know that he was actually taken into custody or apprehended. Okay, any other questions? Very good question. Okay, it's time for a break. May this witness be excused while we have a break, or does she need to come back?
May I ask one follow-up
You
based on a
may.
jury question? These pictures, you did not take them, but were they taken that night?
Yes.
No further question. On my end, she may be excused.
On defense's end as well, Your Honor.
Thank you, officer. You may be excused.
Thank you, officers.
And then I'm going to give the jury a break. They do need to go down. They have 11 minutes before Treasury closes, so.
All right.
All right. It needs to be open until 5 o'clock, just like. Yeah. I don't know why they get special office hours. And then, well, they said they were moving to debit cards after we switched buildings.
Oh.
Because we're not in the same building.
Hmm.
Why don't we
Like
just do
giving
it now?
them debit cards?
Why don't we just do that now? You can be seated.
Oh, sorry.
Thank you. We wait for the jury to see, then we can. Okay. All right, you can call your next witness.
People call Sarah Wilson.
Oh, yes.
So give it to the clerk.
Very sad.
Oh, okay.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth on the penalty of perjury?
Yes.
You can state your first and last name and spell it.
Sarah Wilson, SARAHWILLSON.
Detective Wilson, how are you employed?
I'm a detective with the City of Lansing Police Department.
And how long have you been so employed?
I've been with the department about 18 years. I've been a detective for about 7.
And are you assigned any particular role as a detective?
I'm in the domestic violence unit,
And how long have you been in domestic violence?
about 2.5 years.
And what responsibilities do you have as a detective in domestic violence?
Primarily, I follow up on reports taken by patrol officers for any additional information that may be needed, primarily for non-custody cases where there wasn't arresting aid. Sometimes I do follow up for arrest cases as well, but gather more information and people call it was if they identified themselves.
Sorry, you booted us after 8 hours. Here you go.
It's basic information about what the officer is being asked to respond to.
And did you go about obtaining a CAD report in this case?
Yes.
Showing the defense table, code exhibit 9. Running my first witness?
Yeah.
Now, exhibit 9 there, is that the CAD report that you obtained in this case?
Yes, that is correct.
Now, can you look at the very last page of this packet? Can you please tell me what that document is?
This is called a certification of records. Basically, a notary certifies that this record is authentic. Having come from the agency who supplied it, it's an authentic record.
At this time, the people move to admit code exhibit 9.
No objection, Your Honor. Yes, maybe.
Okay. Now, back to that last page, I believe it mentions how many audio files did it mention?
It mentions 5 audio files.
Okay. So that packet that we have, was it connected to any 911 calls?
Yes, it was.
And have you had an opportunity to review those 911 calls?
Yes.
I'm going to go get exhibit 9 back from you. Thank you. And so those 4 911 calls were, those 5 911 calls, were they connected to the incident described in this CAD report?
Yes.
Now, if you were to hear snippets from I guess before these 5 911 calls, would you recognize them?
Yes.
And showing defense table, I'll give it 1, 2, 3, and 5.
You said, 1,
1, 2, 4, and 5.
4.
We already admitted 3. Was that one of the calls?
Yes, it was.
So what was it? Now going to people's 2. You recognize that?
Sounds like, yeah, she's talking to the dispatcher.
Now moving to people's 4. Is that also one of the 5 calls?
Yes.
Now finally going to people's 5. And was that one of the calls? Your Honor, this time the people move to admit proposed exhibits 1, 2, 4, and 5. Right, we'll start by publishing exhibit 1.
County 911, what's the location of the emergency?
6203 Glovenberg. James Samar Davies, and he got a gun on him. He got a gun on him.
Hold on 1 second. Who had the gun on him?
James Samar Davies.
Jalen?
Samar Davies, 6203 Glovenberg.
Okay, is he threatening anybody with a gun?
No, but he got one on him.
Okay, tell me exactly what happened.
He started me in my face. But I started not to fall down there because he's trying to make me look like the bad person. And I'm not.
Did you able to hear this with me? Everyone hearing it okay?
Yeah.
Right here in my house, won't get out.
Okay.
Won't get out of my house.
All right, and how old is he?
23.
What is he wearing today?
He's wearing jeans, black shoes, a black hoodie.
All right. Do you need an ambulance?
Yes, I do. You put ambulance.
Okay.
Go ahead, man. Don't hear about today, brother.
All right, can you stay separated away from him?
I'm sorry.
Okay.
Oh, we're in here.
What is your name?
You're not here so far, right? With you, bitch.
What is? Okay, can you not argue with him anymore?
He's still hitting me.
Okay, can you separate yourself away from him? Whether it's going outside or going into another room.
Get out my house. Get out my house. Get out my house. Get out my house. Get out my fucking house. Get out my house. Yeah. Get out my house. I am.
Grovenberg is going to be safe right now. Of course, Finland.
He's trying to sue somebody. He's trying to sue somebody right now.
Okay, does he threatening anybody right now? Hello? Stop. Okay. Is he threatening anybody right now with the firearm?
You at my house? You at my house?
Okay. What kind of car did he leave in?
He's not in the car, he on foot.
Okay, which way did he leave?
Out my back door, going towards Edgewood. I don't know where he went, but I didn't have to lock on my door.
Okay, did you make sure they're on lock?
So let's no, they're not on lock at all. But I'm gonna make everything clear. We was arguing. He tried to make me look like a bad person. He started turning the camera on me on his head, so I smacked his phone. I smacked his phone. He smacked me in my face about 5 times. Look up. Look up.
All right, we got police on the way out there, okay?
Okay. And he just smacked me in my face while I was on the phone call.
And he said he's leaving towards Edgewood.
Yes, anytime I heard that back on his face, that was from his phone. He kept hitting me.
All right, we got an ambulance and we have police on the way out there, okay?
Okay.
All right, if he comes back, give us a call back on 911.
All right.
All right, bye-bye.
Now publishing exhibit 2.
Dean County 911, what's the location of your emergency?
I have a lady that just came from her house on Doverberg, because her ex-boyfriend had a gun.
Okay, where on Grovenberg?
She just said he's back at the door, knocking at the door. She just texted me.
What's her name?
Huh?
What's her name?
Ray.
What's her name?
Her name is Ray, 5203 Doverberg.
6203?
Yeah, she literally just texted and said, can you come get me? She at my door right now, knock me, please.
Okay, what's your name?
Ray.
Okay, stay on the line with me. Something Karen 3 call 6203 Grovenberg. The female staying the call. The guy is back with a gun.
Awesome.
Okay, what you said your name is Ray?
Yeah.
What's your last name?
Fox.
What's the girl that texted you's name?
Her name is Sapphire. I don't know the guy name. I don't know her boyfriend name. I don't know what his name is. So that was she was actually. I don't know. I don't know.
Okay, I've got the call. What's your phone number?
517-377-6741.
Okay, thank you. I'll be right on the way, okay?
All right.
Great, thanks. Thanks.
This is People's 4.
Bingham County 911, what's the location of the emergency? Hello.
Hi, I just supposedly just came to 6202 Goldenberg. You
Okay.
at my home, knocking on my door.
Okay, one moment. What's your name?
Sapphire. Yeah.
Okay. And you said he's knocking on your door?
Yes, he's knocking down.
Okay.
Like, I need to hurry up and get here ASAP.
Okay, what door is he knocking on, the back or front door?
But
Okay. All right, we have police out there, okay? I'm just gonna stay on the phone with you until they get there. Let me know. Okay, let me know if he stops knocking, let me know if he walks away, and which way is he going.
Anybody outside anyway, so yeah, you're going to go to jail on it. I want you to get locked up, and you just sit here and just knock me the fuck up. Boy, get the fuck off. You're going to jail, bitch.
Okay, can you tell her not to argue with them?
Just like she said, don't argue with him.
If he's still out there?
Yeah.
Okay, and if he's still at the front door? Okay. Let me know if he takes off from that front door.
He just got, he was hungry just like I know. So he ran the post to their house. I don't know. I had my door locked. They got guns out, everything on the door, so.
Okay. I will go ahead and let you go.
Okay, thank you.
Okay.
And this is People's Five.
Beacon County 911, what's the location of your emergency? Hello?
Man, I called multiple times. He's breaking into our house right now.
Who is it?
6302 Goldenberg. He's literally breaking into her fucking house.
6302?
Goldenberg, the same house I was calling y'all about just a minute ago. He's breaking into her house. Her face is already fucking swollen. He's steady trying to get in her house. He's breaking the fuck.
Sure. He's breaking into the house right now?
Yeah, I got her on the other end, but I can't merge the call with you. She's literally talking to him through the door, scared in the bathroom.
Okay, stay on the line. Stay on the line with me. I got help on the way.
Go ahead.
6203 Gopherberg, he's back trying to break into the house.
He's taking off on y'all.
Okay, what's your name?
My name is Tom.
Is this Ray again? Is this Ray?
Yes.
Okay, Ray, I spoke to you earlier.
Yeah. He's really hiding in the woods on y'all.
Okay.
Because he's staying right there by her house. So he's going from Goldenberg to Georgetown and hiding in the woods.
Okay.
Because I was.
He's on the porch right now?
He's breaking in her house.
Okay.
I'm literally on another phone with her. I just pressed to call y'all. It was put me on hold with her, so I can't nurse the call. Okay. And her daughter's right there and everything.
Yep, I got lots of help on the way, okay, right?
He's hiding in the woods on y'all. Either he's laying down in that grass in that woods or something, but he's staying close to her house. Because he's shot.
Okay.
And he's not, he has no car. So the only way he's getting over right now is through bus. And he's not trying to catch no bus right now because he wants somebody to come over and try to do it.
Okay, I got lots of help on the way, okay?
Yes, please.
Yep, they're on the way, okay?
Yes, this has been multiple times for her and him.
Yep, we've been aware of the situation.
This is not the first time she got beat up by him or none of that.
Okay. We've got help on the way, okay? I'm gonna let you go.
All right.
Now, can you remind me, how long have you been specializing in domestic violence as a detective?
I've been practicing about 2.5 years.
2.5 years. And How many domestic violence cases have you worked on in those 2.5 years?
I mean, I did anywhere from 30 to 40 a month, I would say. I'm fine.
So would it be fair to say hundreds?
Hundreds, yeah.
And in your experience working on these cases, is it unusual for someone who reports a domestic assault to then not follow through?
No, it's not unusual.
How frequently does that happen?
I don't know if I have an exact number, but I mean, it's pretty frequent. If to guess, over half the cases probably.
Okay. So you would guess it's more often than not?
Yeah.
Now, have you personally undertaken any efforts to get Sapphire Font to court today?
I did go out to what I understand is her current residence, and she had mail for in her name mailbox there. Yesterday I went out and I asked new ship to come to no contact with me.
So when you say you went out there, did you go out there with a subpoena?
Yes, it is.
And did you leave a subpoena at her house?
Yes, it is.
And you said noon shift, are you referring to like road police?
Yes, that's correct.
And so did you ask for their assistance with serving the subpoena as well?
Yes, it is.
I have no further questions. Thank you.
Detective Wilson, one of the main reasons for your follow-up to Ms. Bant was to gather a late report from her, isn't that correct?
Yes, I did call her.
And that's because there was no report from her regarding the second and third alleged returns of Mr. Davis to her house that night, right?
Yes, I think there were at least 2 times that it was reported he had returned, that I didn't see an additional statement from her.
No statements from her. Correct. However, when you called Ms. Bant, she wasn't forthcoming about that night, was she?
She advised that she didn't want to talk to me about it.
But she also denied having seen Mr. Davis.
Objection, calls for hearsay.
Respond to the objection.
I'll refresh one. Did she recant having seen Mr. Davis that evening?
Okay, I'm gonna object because it still calls for hearsay.
What's credibility? So I'll allow the question.
I wouldn't call it a recant. I asked her specifically, I believe about approximately 10:30 p.m. There was 5 911 calls total. There was a call at approximately 10:30 p.m. Where it was a neighbor calling. And I asked her if she had actually seen Mr. Davis that occasion. She told me she had not seen him specifically that occasion. I asked her about a call that was closer to 11:30 p.m. and that was when she advised me that she didn't really want to talk about the situation.
So to be fair, you weren't really able to gain any meaningful evidence from this case, were you?
I didn't.
But you also weren't there that night, were you?
That's correct.
You never witnessed Mr. Davis strike Ms. Bant, right?
I was not present. No, I didn't. Okay.
And you never arrived at the scene to encounter Mr. Davis.
I did not.
You never made contact with Mr. Ray Fox, I believe, was mentioned in these 2 911 phone calls. Is that correct?
That is correct.
The only caller who was actually on scene was Sapphire, though, right? Based on these 911 phone calls.
I believe there was a caller named Eugene who was also a neighbor who told me contact her.
You also mentioned having 30 to 40 cases like this a month.
That's correct.
It doesn't leave a ton of time for investigation, does it?
That's correct.
No further questions.
In your experience, is it common for people to give fake names when they call 911?
It certainly happens, yeah.
Is it common for people to not want to get involved in the police with the police? And regarding this Ray person, the second call we heard from him, did he initially give a different name that wasn't Ray?
Yes, the initial setting was Tony.
I have no further questions. Thank you.
Any questions from the jury? Counsel. It's not real. Okay, Detective Wilson, do you know if there's been any reports or evidence to support damage to the alleged victim's front door?
I don't have any independent knowledge of that. I'm not certain if that was in Patrol's original report.
You said.
I'm not certain if that was in Patrol's original report. I don't recall any.
Oh.
I wasn't there. I haven't personally looked at the report.
Okay. And then, do you know the date and or the times of the 911 calls that we just heard?
They were all received on October 30th, 2025. They were between approximately 9:20 p.m. and 11:30 p.m.
And if you know, do you know where the 911 caller, Ray or Tony, do you know where he lives?
I do not know where he lives now.
Okay. Any other questions? Very good. May this witness be excused?
That's one follow-up question. Would the CAD report have information about when different calls were placed and answered?
It often does, yes.
That's all the follow-up.
I'm sorry?
That's all the follow-up I have from my
Oh,
end.
okay.
Should be excused.
This will be excused.
Can I ask one follow-up question?
Sure.
In your general day-to-day, wouldn't you be expected though to go to the scene of a crime like this that had been reported to see if there was damage to the door?
Generally, Patrol gathers that information. They would photograph. They photographs of any damage or ask about damage to the door. There are occasions I go to the scene.
Thank you for clarification.
We should be excused.
Yes.
Thank you, Detective. You may be excused.
Thank you, Don.
No problem. So this is from the people.
No, Your Honor, the people rest.
We will give the jury a recess while we see what the defense is going to do. And did we get this answer? If not, we should go. All right, so the jury, you're not free to deliberate at this time, just to have a quick break while I discuss something with your attorneys.
Leave your notebooks. Yeah. leave notebooks, leave them on the chair.
You can leave your notes on your chair.